Welcome back to the LTL podcast. It's Friday afternoon and it is August 18, 2023. And welcome everybody into this kind of quick, spontaneous pop-up here. And we're going to read some live tweets. We have live tweets from the courtroom that just kicked off about a half an hour ago. I was running a little bit late. It's kind of a spontaneous stream to catch up on here, but hopefully, excuse me, everybody will jump in here in a moment. I'm not sure if Brian Enton is down there today, but I picked up Guy Tenenbaum is in there. I'm going to actually pull up his tweets here, and let me add these to the stream. And this was about 40 minutes ago. So Guy Tenenbaum says, waiting outside the Latah County Courthouse for the latest hearing on several motions in the case against accused Moscow murder suspect Bryan Kohberger. Follow along here and at KHQ Local News for live updates. And I forgot to let everybody know this is episode 59 right now. So this is a photo right here outside the Latah County courtroom. And this was at about an hour ago. So now Guy Tenenbaum, 34 minutes ago, says all settled in the courtroom, should be underway shortly. He comes back 29 minutes later. Mr. Kohberger has just arrived in the courtroom wearing a suit and tie. Judge John Judge has just walked in as well, and we're on the record. Several motions on the docket this morning. This was 22 minutes ago, including a motion to stay the proceedings and discussions on genetic genealogy during the discovery portion of the case. Mr. Kohberger's defense will be testifying first, but not after the state raises objections to their witnesses. Now, I thought there was supposed to be live. I thought there was supposed to be video in the court. Probably what's going to happen is this probably be taped, or audio will be taped, and they'll probably release it later on, which, obviously I'll play that up later. Hey, good to see everybody here. Let's see, we have Diana's in the room. She said, hey, I'm reading from the tweets of Alex Caparillo. Danielle's here. Susan Lee Trainer's here. Susan Trainer's here. Thank you. Hey, she said, hey, I made it to a live stream. Nice to see you. Good to see you too. Natasha's here as well. Little Love is filling in. Injustice 13 says, I think it's live on that link. Is it live? Let's take a look. Hang on one second. I don't see anything live. Let me go to, let's see. It's supposed to be on Court TV. Well, let me take a look at Court TV and see if they have it up there. Again, really quick, spontaneous stream here. I don't see anything live on Court TV. So let me see if there's any streams going. Bear with me for a second here. If not, we'll continue to read through the live tweets. Nothing. There's no live streams. All right, hang on. Court hearing here. JLR is live. I got it. I got the feed. Hang on. I got it. If anybody has the link, if any of my mods have the link, I'm gonna pull
Was a
up
pretty
Peter
big
Tragos
decision, and I think that
on with
um,
WFLA News.
I don't know if the camera's on the right thing. There we go.
There we go.
So
Let's
I
hear what
don't
Peter has to say.
I don't know that it's going to happen in October. I would say it's still a very, very, very slim chance. I think that 37 days was important, and I think there's a higher chance it happens between October and
I don't know if they're
December
gonna
of
cut into the feed, but
2023.
we'll hang out here and
If
see
the
what Peter.
court will grant some more short stays potentially, but I still think most likely is it's going to get continued out, and it's not going to be something that happens within a speedy trial period. That's kind of how I felt the entire time. But I think as long as the court
it's
gives
cutting it out.
some small extensions every time something like that is given, I think it's more likely that the trial happens within this period.
Let's go to Angie's question. Wants to know, are they keeping him isolated in jail? What do we know, Peter, about Bryan's stay there in Idaho as far as
I have the
him
tweets,
being locked
but I
up?
kind of want to hear this.
I don't know the answer to this. I think I remember reading somewhere that he was, but I honestly am not positive.
Yeah, I mean, well, let me ask you this question: how often do you think he's meeting with his attorney? What would be standard? I mean, how in a situation like this, high profile murder trial is expected to happen later this year or in the months ahead? How often would it be, sort of normal for for someone like Bryan Kohberger to be meeting with his attorney?
So let me read through some of these tweets. Let me go back because I don't think there's anything live right now. I'm going to go back to the tweets. Give me 2 seconds here. So went into several motions on the docket this morning, including a motion to stay the proceedings and discussions. And we'll go back to that live video if they have anything. But I want to read through these tweets. Mr. Kohberger's defense will testify first, but not after the state raises objections to their witnesses. And then he goes on to say, Guy Tenenbaum says, defense says the prosecution knew about these witnesses ahead of time and didn't raise their objections until today. Defense insists their testimony will be relevant to their motions to compel the state to hand over DNA profiles they gathered in discovery. Judge says the proposed witnesses could have been provided background into the genealogy. He adds that because this is a death penalty case and it's important to add these witnesses to the record. And he also wants, let me just bring this up a little bit. Ah, shit. Sorry. Where was I? And he adds, because this is a death penalty case, it's important to add these witnesses to the record. He also wants to make sure that both sides are heard, but overruled the objections. Guy goes on to tweet 24 minutes ago, defense is looking for information on the 3 DNA profiles that aren't connected to Mr. Kohberger, 2 in the house and 1 in one, 2 in the house and 1 in the house. State argues that they don't have those profiles and that they're given everything they have to the defense, still waiting on 1 lab report. Prosecutor Thompson, we've given everything we've gotten from the lab. I don't know what else to say. We've given everything that we know to exist. So definitely things are heating up. Definitely things heating up in the courtroom. Defense also asking for a log of communication between prosecution and lab. Thompson is getting a little fired up. He says, they're asking for something that doesn't exist. We'll put it in another inquiry to the lab for other communications. But as far as we know, everything has already been proven to be the defense. Guy goes on to say, witness being sworn in, Stephen Mercer defense starting their questioning. He also is a licensed attorney from Maryland and DC with the area of specialization in DNA and forensic investigation. So definitely things are heating up in the courtroom during this hearing. Let's go back to the video and I'll just keep awaiting any tweets. Let me go back to this video here. We'll go back to Peter Tragos and
from
FLA News.
Either one of the two hashtags for us both.
I welcome everybody into the coverage. I hope you're enjoying this rapid fire stuff going on today.
This is a question that people wonder about. The reality of the conversations that take place between a client and who they hire to represent them.
So what I'll say is his lawyers know what Bryan Kohberger is telling them, right? So if he admits that he did it, then they know it. If he says he didn't do it, then that's what they know at this point. Regardless of where the evidence points them, if your client said you didn't do it, that's usually what you go on. Now, a lot of times when a criminal defendant may admit guilt.
God, Peter's connection's bad.
To their defense lawyer. Some defense lawyers state prove that case beyond a.
Okay, we got another tweet. I'm going to bring that back up. Go back over here. StreamYard, you really now need to start acting so we can add multiple media tabs. This cutting and going back and forth is crazy. Let's see. Mercer also, all right, so it says, let's see. Mercer, witness being sworn in, Stephen Mercer says he's here to offer his experience in forensic information as it pertains to the defense of the case and providing background into why attorneys should investigate DNA evidence and do their due diligence. He says it's crucial for the defense attorney to know about the testing methods for DNA profiles to ensure a fair trial and investigation, especially when making challenges in the case, including relating to the Fourth Amendment pretrial. Guy goes on to tweet 9 minutes ago. Mercer also adds, it crucial for the defense attorney to investigate how reliable the testing methods of the DNA profiles are and the reliability of the testing results themselves. Very, very interesting. Very, very interesting. Heating up. Daniel says, I was sorry I was in the other rooms and I heard mods. It takes me a long time walking on the crutches, and I'm sorry. I'm sorry that you're on crutches. I hope you're feeling better. But thank you for being here. And we're going to wait and see if there's any updated tweets. I'm going to refresh here in a second. Let's see. Mercer also adds it's crucial to the defense attorney. And yep, so we've already got that. We'll wait a couple more minutes and I'll refresh. I'm going to go back to the live feed with Peter Tragos for a couple minutes here, and then we'll go back and switch back. Let's see.
It's not a simple sort of question to answer, but here, do your best there, Peter.
So the answer is they can, and if you mean his lawyers, they can do a lie detector test on him if he wants to submit to it, if they want to use it and see whether or not they believe what he's saying, or test his credibility, or see how he comes off as far as reliability goes.
You hear?
There's no jurisdiction I'm aware of in the United States that where lie detector tests are admissible evidence in court. There's a number of reasons for that, but basically their reliability can't be tested well enough. And some people have been known to be able to beat lie detector tests. And then you don't want jurors to put too much weight on something that can be beaten just in case it was beaten. So therefore, the defendant just takes the stand if he wants to testify, talks to the jury, and the jury determines whether or not they find him credible and if they believe what he's saying or not. So his lawyers can put him under lie detector test if he wants to submit to that and try to help prove he's telling the truth to his lawyers, but it's not going to be something that's used at trial.
Yeah, it's not a 100% foolproof technology, folks. I mean, people forget that. They think that it's going to be an automatic, oh my God, this person is guilty or not guilty. But there are many ways for, well, it can be fooled. There can be problems with the technology as well. And while we do hear about it a lot in movies and TV shows, actually
no new tweets yet. Still waiting on Guy Tenenbaum.
It just doesn't give you 100% certainty. Destiny, thanks for the question here. Let's go to my bet, because it brings up a great point. If he has an alibi, why wouldn't he plead not guilty? Didn't the judge have to plead for him? And this is a good question, because again, let's remind, he decided to stand silent, which means that the judge in this case entered a plea of not guilty for him. So to this question, if he has this alibi, why exactly wouldn't he just enter a plea of not guilty, in your opinion, Peter?
So it's a good question by my bet, and it's really something that, if we want to think logically about this, makes sense. If you didn't do it and you want to say you didn't do it, why don't you stand up in court and say, I didn't do it, I'm not guilty? But when we come to legal procedure, if there are reasons and ways to do something that have the same outcome, but you believe or your lawyer believe it protects rights in another area, then you're going to go with that. Because the way that they did it standing silent, his lawyers have filed in other motions that they felt it preserved certain rights in the grand jury process, and objecting to that grand jury process By standing silent, they were able to preserve those rights while also having the same exact effect legally as pleading not guilty in this situation that you were saying. He's still saying he didn't do it. He's still saying he has an alibi and therefore he's not guilty, but he did it with the judge's words instead of his own in order to preserve another right that, whether I agree or disagree with that second part, doesn't really matter. That's why I believe Bryan Kohberger did it in this situation, is it had the same legal effect by standing silent as if he would have said it with his own mouth that he was not guilty.
Yep, and of course he had his own legal reasons for doing so, and we still don't know if that was upon the recommendation of counsel or if that was his decision to stand silent. Of course, much has been made of that particular decision. Peter, we're going to let you go. Of course, I promised I would get you out of here at 2:30, so you're going to be live on your channel. We appreciate your time being able to lend us your expertise, folks. If you want to, of course, follow Peter Tragos, you can do so. He is known as the lawyer you know across his social media platforms, including now Twitter/X, I think we can call it Twitter/
whatever it's called.
Yeah, whatever Elon's calling it this week. You can find Peter at lawyer you know. Peter, I'll get you out on this really quickly. Multiple witnesses, multiple experts are expected to testify here today. We do have the time zone difference, but how long do we? I asked you this by text.
Yes,
You
we
may
are
have texted
live
before the stream.
Welcome in.
We have heard the same thing about the expectation that this hearing is going to be somewhere in the 60 to 90 minute range. But if these exchanges go on in court for a long time, is there any chance that this goes on all day or even, my goodness, into next week? Is that even remotely on the table?
I think Peter froze.
And I think we froze on you, Peter, again.
Well, there he goes.
I think we're good now. So I think the judge would do everything he could to finish this tonight,
great.
even if they have to stay late or cut off how many experts they can call, or maybe make them short.
No
some
new
of the
tweets.
expert witnesses. I think it's going to take a couple of hours now, because I think it could have been limited if the state would have agreed to certain things, or we're going to turn over this DNA stuff, not that. But it seems like there's not much they've agreed to since the last time they spoke. We're going to have to hear from the expert witnesses. The judge is going to have to make a call after both sides make arguments. So I expect it's going to last a couple hours, but I would guess it's going to finish tonight. There's no guarantees, though.
You know how I know you're good at what you do? Even when you're frozen, it's not one of those really awkward faces where you have one eye open and one eye closed and you look like, you look all blurry and everything. Even when you freeze on me, you're still looking as sharp as ever. Peter Tragos.
I work on that specifically,
Peter Tragos, the lawyer you know, friend of the program and total pro here in the Tampa Bay area. Peter, thanks a whole lot. You and I will be texting, I'm sure, and we'll be talking about.
I want to welcome everybody in as the chat.
Man, thanks for having me.
Thanks for coming on. And folks, again, the lawyer you know, you can follow him on his respective channels. Peter's always great to have on the program. Back here with you live on stream, JV Buno here with you in the WFLA Now Stream Center. Again, we are awaiting the feed. I have all of these screens here in the Stream Center for the purpose of being able to punch up and calibrate the shot from Idaho. What is going to happen is the hearing is going to play out today. Right now, they're doing an expert.
No new tweets from Guy Tenenbaum.
This is
still waiting.
Something that began at 10:30 Pacific time. And of course, 1:30 Eastern. It's going to play out for however long it's going to play out. Again, Peter and I heard about 60 to 90 minutes. But if this goes on for a couple of hours, that'll delay, of course, when we can actually begin distributing the feed to you. We're going to have it here on this live stream, the exact feed out of the courthouse from the pool camera team. We'll be able to share that, but we cannot begin transmitting live streaming that signal.
I wish that's
until,
my dream.
Of course, the hearing concludes. So we're all just kind of following some of the reporters on social media.
We'll see
on Twitter. Yeah, I'm still calling it Twitter because it's weird calling it X. X just sounds weird, you guys. It does. I'm trying to
no new tweet.
Do my best to get into it, but it's just weird to say we're following along on X. It just doesn't sound right. It doesn't roll off the tongue like Twitter did for so many years. But we're gonna, of course, follow the play-by-play with some of the reporters, including Alex, who again is with News Nation, and he's live tweeting this. My goodness, thank God that we have we wouldn't really have much to go by if phones were banned from this courtroom. Like in many federal courthouses, usually reporters are not allowed to bring in their phones. Here in Idaho, they can bring their phones into the courtroom. So of course they are able to live tweet, and we're following a lot of those tweets as they unfold. But really, this is just a place for us to answer some questions. I'll do as much play-by-play as I can. I might have to pop off stream or at least mute microphones because we do have other stream programming that we are likely going to be providing today for wtfla.com. So there's a chance where we might take a break at some point, but stay with you up here live on stream, of course. And I'll do my very best to answer questions.
Thank you, Danielle.
I
I appreciate you.
the conclusion of this hearing so that
I
we can watch.
Welcome everybody into
live,
this live
or
stream.
at least as live.
We're
semi-live.
Kind of play-by-playing the courtroom activity in Bryan Kohberger's case. There's not really too much activity. We just had Peter Tragos on WFLA and just giving some perspective of what's going on today, but I'm still waiting for some live tweet updates, and we're watching WFLA right now. This is not video from today.
Courthouses all the time. Hopefully they'll understand that he's just trying to do his job. So
well, I'm going to check and see
really
if there's
quickly,
any
folks, let me just check in here
updates.
with our team for 1 second, and then we'll start going back to the
okay. We have a live tweet update. I'm going to go back to that and read it for you all. So let me stop this. Oh gosh, come on, StreamYard. You gotta add multiple media tabs. That's the next thing that you need to do. Okay, Guy Tenenbaum tweets a minute ago, defense has finished questioning Mr. Mercer. Prosecution does not have any questions and he is dismissed. We've entered a 10-minute recess. So they're on recess now for 10 minutes. We're gonna hang out here. We're gonna go back to WFLA and let's pull that feed back up. Let's see what's going on over there.
Of course, this goes back to some of the cell phone pings that investigators say that they have, digital evidence that he was in the area, of course, driving around.
Just driving around
the time of the murders of the 4 students at the University of Idaho in Moscow. And so we were just informally, casually asking you as to whether or not you casually go for drives anymore.
Mm-hmm.
I can share that I can't remember the last time I just went for a drive. I'm trying to think of like the last time that I did that. And it's just not something that usually when I'm in my car, it's because I need to go somewhere or pick up somebody.
All right, what I want to do today, what I want to do right now while we wait for new feed to come in, we're on a 10-minute recess in court, but I wanted to play this from, let's see. What's the tab I want? Hang with me for 2 seconds. Let's see. I wanted to play, while we wait for that 10-minute recess, I have a video from this was last night on Banfield. Steve Gonzalez joined her panel. Let's hear what he had to say about the proceedings that were going on today.
Because he's Kaylee Gonzalez's dad, one of the 4 victims of the Idaho murders, and he's here with me live. Steve, thank you for being here. We haven't talked in a while. Are you and Christy planning to be at the hearing tomorrow?
Yes, we'll be there tomorrow for sure.
Wow. Steve is there today.
I suppose when you read the prosecutor's response to Bryan Kohberger's lawyer's assertion that, that the proceeding that led to the grand jury indictment was unfair, I suppose when you read nonsense, you felt the same way or maybe more.
Well, I feel like we definitely understand what unfair feels like as parents. There's 6 motions that are going to happen tomorrow, which makes it a very important hearing to be at. So we'll be there and we will be watching everything, recording everything. I have my legal counsel there, and I want to make sure that
I hope so, Angela.
he
Thank
understands that he has a whole team of people after him. It's not just the prosecution; it's all the families. We want justice, and we're looking for all this evidence. That's why I want to know about the alibi. We want to know about these different motions, and give him the opportunity to defend himself.
Okay, let's talk about that alibi, because I haven't spoken to you since he actually announced this alibi story that he was out for a long drive between 3 and
Steve's face.
4 or 5 in the morning. You know, can't prove his whereabouts, but that's the
Just
story.
driving around.
What was your reaction when you saw that actually on paper?
It helped me understand that we do have the right defendant, and there's some computer models that are out there that kind of correlate patterns and speeds and times that people could be going through that neighborhood and how they would
Interesting.
match along those surveillance cameras.
Interesting.
So I understand the difficulty of being able to come up with an alibi that fits that, but the jury will be able to see all this on their own and make that decision.
Yeah, coincidences, one coincidence people can accept, two, it gets harder, three or four, like I just happened to turn my phone off for that specific time that I was out for my long drive in the darkest, deepest time of the night.
So real quick, I'm sorry, I'm just going to pause this for a second. I got some people filling into the chat room. I just want to welcome everybody into this kind of pop-up edition of LTL today. What we're doing right now is we're reading live tweets from the courtroom. We're on a 10-minute recess in the courtroom right now. When that 10 minutes is up and Guy Tenenbaum begins to tweet again, I will go back to that. I'm just kind of switching around right now, giving some context in between us waiting. And this is a interview from last night with Banfield, Steve Gonzalez. Last night, Christy and Steve are in the courtroom today for this hearing, and we'll play through the rest of this video here. And then I have another video from, I believe it was Law and Crime Network, that will give you a little bit more of a detailed breakdown of what they're actually talking about in the courtroom today. All right, let's keep playing through this.
It starts to get, pretty tricky. One last quick question. How are you guys doing? We are, coming up on an anniversary this fall that's going to be very difficult for you and your kids and for the other parents as well. How are you guys managing?
You hope that it gets better, but truth is,
thanks for being here, Gloria. I appreciate you.
As Kaylee and Maddie and Ethan and Xana, it never gets okay. It never feels good. You don't heal from that. So I have a job to do as a parent, and I hope everybody understands what we're doing and what we're going through.
I think most people will absolutely understand that, but having never walked in your shoes, they'll never truly get it. 46 days. I don't know if they'll grant him a stay, whether there'll be a delay in that, but 46 days, that's coming soon, the start of this trial, at least the scheduled start. Steve, thank you. Please give my love to Christy and the rest of your kids, and be well, my friend.
Thank you.
All right, let's go over to this was a video from Law and Crime Network that's going to break down a little bit more what's going on in the courtroom today. It's about an 8-minute video, and I promise I will resume the live tweets from Guy Tenenbaum when that recess is over.
Is expected to be there for a series of motions. Kohberger charged, of course, with 4 counts of first-degree murder for the deaths of the 4 University of Idaho students. They were
One thing I will say in this video that I remember that they did talk about was, being ready. Is the defense ready? And what my opinion in all of this is, I don't think that they are ready. They constantly keep putting in motions. They're constantly attacking, the time, asking for more time. So again, that's their job. The defense is to do that. But it really seems like Kohberger in this case wants the speedy trial. And it's his defense, his team, that's seemingly looking like it's trying to keep slowing it down. We'll hear that what's actually going on in this video.
This was December 2022. And our very own Anjanette Levy joins us now to talk about.
Thank you, Angela. Appreciate you.
Anjanette, good afternoon. Never a dull moment in the Kohberger case. So, what is going on with all of these motions? What are the bullet points there?
Yeah, good afternoon to you, Michael. There is certainly never a dull moment in this case. Basically, there are going to be 6 motions that are heard today, 3 from the prosecution and 3 from the defense. One of the most significant of those, I believe, is one where the prosecution is asking for a protective order for the investigative genetic genealogy that was used to identify Bryan Kohberger as a suspect in this case. And they did that by taking DNA, a single source male DNA sample, according to the prosecution, from the snap of the knife sheath left next to Maddie Mogen's body at the crime scene. And they ran that through CODIS, which is a known database, they said we have to take another route. So they sent it off to a private lab. Private lab developed a different type of profile, sends it off to the FBI. The FBI works their.
Oh, real quick, Carrie H, check your email. I emailed you. I just had 2 questions for you. If you can answer that to me, we'll take care of something. So check your email. I emailed you this morning.
Magic. They go into a bunch of portals, they build family trees, and then they go through and try to find common markers, and they end up with Michael Kohberger, who is Bryan Kohberger's father. That leads them to Pennsylvania and Michael Kohberger's father, his family home, and the place where he was residing during the holidays, but right before his arrest in December of last year. Now, the defense is saying, we want this information. Prosecutors are saying, we shouldn't have to turn this over. The FBI didn't take notes when they were doing this. They don't even have the information for us to hand over, but there have been other cases where this technology was used and the judge didn't require, the prosecution to turn these materials over to the defense. The defense, meanwhile, says that's not acceptable. You're trying to put our guy to death for a quadruple homicide. We should see the roadmap you used to identify Bryan Kohberger as a suspect, because this is what led you to him and led to your further investigation of him. We should see who you excluded and who you didn't. And they have their own DNA expert who is saying there can be mistakes made with investigative genetic genealogy. So this is going to be quite the fight. And I think this is probably one of the most high-profile cases you've seen genetic genealogy used in, aside from the Golden State Killer. And the defense is vigorously pushing back against this. Other evidence that the defense believes the judge should order the prosecution to turn over. As well, the prosecution is objecting to these stays that the defense was granted. They're basically saying Bryan Kohberger said he wants a speedy trial. And so he wants a speedy trial. He should get it. The defense should quit asking for the proceedings to be stayed, which basically stops the clock from ticking on all of the speedy trial stuff and tolling the time for that. So a lot going on today, Michael, but I really think the genetic genealogy part of this could be pretty significant.
Yeah, let me ask you a follow-up on that, because it is fascinating. And you mentioned the Golden State Killer. That was really the seminal case where this stuff was tested. Seems only fair to me that the defense be able to challenge the methodology and the, for lack of a better phrase, the chain of evidence, how that process was carried out. Obviously, if the defense is successful, it cuts the prosecution's case off at the knees. I mean, there's no probable cause to get to this guy, and everything else is poison. So what's the general take on this? Has it been just accepted before?
Basically, yeah. Michael, they have produced cases, at least the prosecution presented one case to the court called the Green case. And that was used to identify a perpetrator. The genetic genealogy was in that case. And so they're saying, look, in this case,
we know, Teresa. Thank you.
They said that this was a tip or a lead.
Well,
they didn't have to turn it over. And the prosecution argues under the statutes in Idaho governing discovery and what is to be turned over to a. They're saying, well, this doesn't apply. This doesn't fall under that. But this was really the key.
It's on
here.
Court TV.
This genetic
I can't find
genealogy,
it.
and I've said this before, they really had nothing to go on. I mean, they had 9,000 tips that first week of December when we were out there. They had released that white Hyundai Elantra surveillance video, and they apparently had this DNA profile that was
Is it on Court TV on their YouTube channel, or where is it? Because I can't find it. Oh, I got it. No, that's not it. Hang on. I just got a small on the web. Yeah, is it free? Because I don't know. I can't find it. I just see a hang on one second. Okay, I got it. Sorry. Thank you for that heads up. Perfect.
We received her declaration just yesterday. There was no CV attached. Ms. Vargas is being submitted to this court as an expert witness, and the state has no way of vetting her expertise without a CV.
Thank you.
There is no way for us to verify anything in her affidavit. It puts the state in essentially an ambush position where we're being presented with this witness with no way to verify her qualifications. We would ask that this witness.
Love you guys. Thank you so much. Thank you.
And then finally, the state would just make a blanket motion of limiting that these witnesses not be allowed to testify about legal decisions or legal arguments. Thank you, Your Honor.
Thank you. Love you guys. Thanks for the help. Appreciate you all.
Your Honor, the first two witnesses that the state objects to, Victor Barlow and Steve Mercer, are two people who have been known to the state for quite some time. What they say to you in court now is their objection was made known on July 14th in their reply to, in support of their protective order after we get a response to their motion for protective order and an objection to it.
If you're just jumping in now, we're watching live feed from Bryan Kohberger's motion hearing. Thanks for hanging out today.
That were attached to our third motion to tell. So that's not an objection to them testifying at all. These witnesses have been made known.
What up, AZ? Good to see you here,
They
man.
were certainly known
See you here.
when we had a planning session and we talked about the number of witnesses that were going to testify. No objection was stated at that time either. Waiting until today, when those witnesses have both traveled and been here and been prepared to testify, that's an ambush, Your Honor. They're here, they're prepared. Their testimonies are relevant to the issues that the court has to decide. They're going to talk to the court about two different things as it relates to our discovery rule and the information that Mr. Kohberger is seeking so that we can do our job. Your Honor, you're going to hear from a witness, Leah Larkin, Dr. Leah Larkin as well, and she's going to talk about the process of genetic genealogy. Both Ms. Barlow and Mr. Mercer are attorneys. Both are well-versed in criminal defense. Both are well-versed in DNA and genetic genealogy. The state's position has been that this is not discoverable because we're not going to present it at trial. That's not the end of the story. That's not the discovery rule. And those are the things that Victor Barlow and Steve Mercer will talk about. Victor Barlow has a lot of training in DNA. She does a lot of teaching on DNA as well. It's not a simple little process, and they'll describe what kinds of materials we should have in discovery. Mr. Mercer will talk about what we will do with those kinds of materials and why they're necessary to Mr. Kohberger's presentation, the preparation of his case. They'll talk about our constitutional duties to Mr. Kohberger. Those are not conclusions. Those are things that have to do with this material, these things that we're seeking the court to order the state to hand over to us, and why they're necessary to the preparation of the case. So for those two witnesses, I can make the argument that I don't have the expertise in the DNA or the genetic genealogy that the court needs to hear to understand that they fall squarely within our discovery rule. Your Honor, I'll speak about Gabriella Vargas now. Her declaration was disclosed yesterday. Much of that declaration has CD-related items in it. It talks about her background for training, right in the body of that declaration. That declaration is not as soon as we would have wanted that. Gabriela Vargas met with me a few weeks ago, and for personal reasons that I'm not going to put on the record, she was unable to complete that until a later period of time. So that, I mean, that one is late. I know that one came in yesterday. She's here, she's prepared to be cross-examined by the state, and certainly there are many other remedies besides just excluding her. The court could allow us to present her testimony, and the state doesn't feel that they've had opportunity to cross-examine her or present a witness in response to her. The court could leave this open and take that up. The court could even order Ms. Vargas to appear by Zoom for further cross-examination. But we should at least let her testimony come out here in court today. She's here, Your Honor.
Thank you, Taylor. Would there be any response?
Your Honor, I think Ms. Taylor has just conceded that these attorney witnesses are going to be testifying about the scope of discovery rules. I don't think that that's appropriate. I think that Ms. Taylor can make those arguments to the court that having fact witnesses interpret the law is not appropriate in a discovery dispute. As to Ms. Vargas, our understanding was that there were 3 witnesses testifying today, and that was our understanding up until yesterday when we got into town. So we would ask that Ms. Vargas be excluded. And I would note that we made our objections to these witnesses clear when we asked the court to disregard the contents of their declarations in Mr. Knight's reply brief. Certainly, we're going to put that same objection on the record. Thank you, Your Honor.
Thank you. Well, a couple of things. I'm concerned about these opinions about sort of constitutional law or the procedures of discovery. I think that's fully capable for all of the counsel here and for me. Those are going to be my decisions. However, in reading through, and I have read through all of the declarations, pointing on specifically genetic genealogy and their experience with that within the law, I think does have some relevance, potentially. And I think that it would go to the weight of the consideration. The other thing that I am concerned about is this is a death penalty case. And if I deny particular presentations that one or the other side
We've hit the top of the hour, so we do have to squeeze in a break, but you won't miss a moment of the Kohberger hearing there in Latah County, Idaho. Don't go anywhere.
All right, don't go anywhere. We're going to come back with a break. You're welcome, everybody. We're going to hang out here for a minute. We'll go back to the live feed when we go resume back to Kohberger. Let me just do this and see if there's anything going on in Twitterverse. I know Guy Tenenbaum was tweeting. Let's see if he has any updates via his Twitter. Let's refresh this and scroll down. I'm trying to stay up to date as much as I can here. Okay, 10-minute recess. Back in session. Important to note, it looks like the Gonzalez family is in attendance. He says the defense is calling Dr. Lee Larkin, a professional genetic genealogist from California, to the stand. It says defense asks how Dr. Larkin can get involved in the case, and she says her role is to educate the genetic genealogy works and the roles in the investigations. So definitely things are heating up in the courtroom today. I want to go back to another video that we were just watching a couple of minutes ago. Excuse me. And we'll tend to finish this off on the break. When Court TV goes back live, I will pull back.
Put a name with it. So this is what led them to do further investigation.
Thanks for hanging out for this rapid fire coverage. It's been super fun for me this afternoon. I love being spontaneous and kind of jumping around everywhere. It gets my blood flowing. I'm sure everybody else is very excited about this. And we'll cut back to Court TV when that live feed resumes.
There have been many other cases where the defense has wanted this information and the judges have ruled they don't have to turn it over. But we'll see. I mean, maybe in this case it will be different. We just don't know yet. This is a capital case where the defendant is claiming he is not guilty, and we'll see what happens.
Yeah, and it's kind of high profile, you know, just a little. So I think it'd be very interesting to see what the court what the court says. You know, up to this point, it sounds like the court is saying through the prosecution's argument that hey, they could just fight about that at trial. They could try to discredit the science at trial, but we're not going to make it a pretrial discovery issue. So this is really fascinating to see how it plays out. Let's talk about the timing. I don't think anybody, I mean, I have a watch right here with an X in the name of this watch, and I would bet this $40 Timex that this will not be going forward on October 2nd as currently scheduled. What's your take?
Is that Timex like 40 years old? And they say
no, you can go online right now and buy a $40 Timex watch.
Excuse me.
I got them stacked up in my wallet. I'm in my closet. I go through them rapidly. But anyway, that's what
so on that point, Bo, you know, please pardon my little joke there. Basically, yes, the clock is ticking. Jury selection in this case, it's a death penalty case. And being a death penalty case, it adds a layer of complexity to everything because the jurors have to be so-called, you know, death qualified jurors, meaning that it adds another layer to the jury selection process. So October 2nd is now less than 2 months away. The defense in this case has received more than 51 terabytes of discovery. That's a mountain, a literal mountain of forensic evidence or, you know, computer evidence, if we're going to talk in computer terms. So they've asked for a stay because they say they aren't getting evidence that they need to prepare for trial. The defense was granted a stay of the, you know, a stopping of the clock, if you will. And the prosecution is saying you're just stalling. This is a delay tactic. You wanted a speedy trial, so let's go forward with it on October 2nd and let's quit stopping the clock. I thought it was very interesting a couple of weeks ago.
Court TV is still on a break, and I just have some new tweets that I'm going to read through here in a second. Let's finish this up here. Actually, you know what? I'm going to just drop out because I want to get to all the latest footage from the trial, the coverage from the trial. So let's see. Tenenbaum says, 40 seconds ago, state tries to object to Dr. Larkin's presentation about genealogy terms, saying that they haven't seen the PowerPoint because they didn't know about until today. Wow. Judge gives them 10 minutes to review it before she testifies. We're back in recess. So they are back in a recess. Court TV is still on a break, and we're waiting for Court TV to come back. I'm going to go back to that video, and then once we get any updates via Twitter or back to Court TV, I promise I'll go back. Little rapid fire session today. Let's go back here to Long Crime Network and finish this
attorney
out.
For Bryan Kohberger wrote in a motion, Bryan Kohberger wants a speedy trial, and this is basically all up to him. And he, you know, this is what he wants. And if he changes his mind, he changes his mind, but this is what he wants. So it sounds like Bryan Kohberger is the one pushing for the speedy trial. I personally, even if you have like 4 lawyers on this case, which you do on the defense team, I find it hard to imagine they would be really ready to go second with this case because they still have to go through juror questionnaires. We still don't know if this trial is being.
Okay, it looks like court may be back. Let's pull this back up from Court TV, the live feed. Let's see what they're saying.
Tried to halt court proceedings over potential procedural issues with the grand jury. Now, on the other side, for the state, the prosecutors will fight to protect information involved in the genetic genealogy investigation. They also have a motion to reconsider the order staying time for speedy trial. And they plan to take up a motion over the defense's alibi claim. That alibi? That Kohberger was out for a drive alone on the night of the murders. The question will be, is that really an alibi? It's important to note, just for your viewing, the judge is not allowing a live stream of the hearing, but Court TV did just receive the first part of the hearing, and now we will be playing you the hearing in its entirety. As we get it in, we're going to bring it to you. Of course, now we'll pick it up right where we left off.
And I'll stay with this. I'll stay this, everybody. We're going to stay with this.
Probably more wise for me to allow it, even if it might be on the edge, than not allow that record. It's especially important in a case like this to have a record for appeal. So I'm not saying one way or the other how this might fall, but I think it's important to preserve the record. Now, however, I don't want to get into arguments about the law or what that exactly means. I think I have a pretty good understanding of what the issues are about the genetic genealogy issues and why the state wants to get more information about that. I also understand why the state believes that it has nothing to do with the case. And that's what I'm going to hear from today. And I think it's important to have both sides weigh in on this. Now, with regard to Ms. Vargas, she is here. I don't know where she came from, how far away. I'm inclined to just allow the state to come back and address that if we need to do that. And also file a brief objection. And I may decide to do that. So that's where I land on all of that. So I'm going to deny the objections, overrule them, and we shall proceed with hearing testimony. Now, if we get too far into this is what the law requires, maybe we can't have objections. Okay?
Thank you.
So call your first witness.
Your Honor, I made one point of clarification. It occurred to me while listening to the court talking about genetic genealogy and really that being a focus. There are a couple of other areas contained in the motion to compel.
There's not. I have it up as loud as it will go. I'm sorry.
Doesn't have complete discovery
It's,
to us.
oh, I can turn it up. Here we go. Is that better?
For today, but they focus has been the genetic genealogy piece.
Yeah, I'll make a driving around one.
That was still in the scope.
Is that better?
Well, my understanding was that
Carrie
the
H,
state
check
did
your
provide
email
all the information about
if you're still here.
laboratory, we'll say the laboratory DNA that was that analysis was not related to the genealogy DNA. Am I mistaken about that?
Sorry,
Or are you
guys.
saying that they didn't provide something?
Your Honor, in our third motion to compel, we had a section called standard lab discovery, and that has to do with other DNA profiles found at the scene. They have provided full discovery for the sheep, the DNA found on the knife sheep, but not the other 3 unidentified male DNA samples, 2 from within the house, 1 from outside the house.
All right. So if I'm understanding your question there, or your assertion that we're talking about 3 potential analysis of DNA that was not provided to you, but that has no connection to Mr. Kohberger.
Correct.
Any response?
Your Honor, we didn't realize this was going to be an issue today. We have given the defense everything that we received from the lab. They've asked for DNA workups on other people. To the extent that they don't have them, they weren't done. We can't produce something that doesn't exist. We provided everything. There's one outstanding lab report that relates to the forensic examination by the lab personnel of the crime scene itself. We received the dead. That's the only outstanding lab report. Everything else, along with all the notes, is what there is, and it's been provided to the defense. I mean, they're hoping that there's something else there. It's not there.
Taylor?
Well, Your Honor, it's part of our third motion to compel. It's still something that we don't have. We also don't have the unexpected corrective actions, unexpected results from the Idaho State Police Forensics Lab for the 6 months before and the 6 months after November 13th, 2022. We did get some, but it's a narrow scope, and we asked for the full year, 6 months before and 6 months after. That's also in our motion.
I understand your responsibility is to turn over every rock, but you can't get things that don't exist as well. So, I mean, there has to be some level of trust in discovery. You're all sworn attorneys. And so Mr. Thompson is saying that there's one more lab report that is coming your way today, I heard you say.
Maybe not today. We are waiting to receive it so that we can process it for discovery. It's supposed to be in any time.
Okay, I misunderstood that. So it's coming soon. It has to come soon because we're 6 weeks away from the trial. So we're going to be very rushed about a lot of things, but I'm going to talk about that a little more later too. So what about the other claim, Mr. Thompson? Do you want to address that? The other mistakes?
Corrective action log, unexpected result log. We have that in part, but not the full scope.
I don't know what exists that we haven't received. We provided all the requests to the lab, and they've assured us that they have provided us with everything they have within the scope of those requests. I'm not sure what else to say. I mean, we can make a supplemental inquiry to clarify that after we finish in court today. But I'm kind of sitting here saying, Judge, has given me everything we know to exist.
Well, that would be wise to check on that.
We will.
Because we don't want this to come back on the eve of trial.
Yes, sir.
Or, 4 years from now at an appeal.
Yes, sir.
So we want to make sure that we have combed through all the information that has any bearing or argument of bearing on this case. That's how.
Ms. Jennings is making a note right now. We'll send the inquiry out later today.
Okay.
Thanks, sir.
Your Honor, just for some clarification, we also ask for all emails, text messages, electronic messages, or other messages. Some have been provided, but we don't have assurance that that's all. And so for the same reason, we want to make sure that we have the complete copy.
Okay, Mr. Thompson.
We have told them.
Let's bring in our guest, Marie Pereira, defense attorney out of New York, joining us. Marie, always love having you on. And this to me is real insider baseball. And what I mean by that is we do this, if you're an attorney who does any kind of litigation, you do this day in and day out because all of this happens before any case goes to trial. But to show viewers the details, the amount of legal wrangling and arguing. And I want to focus a little bit on the forensic genealogy. And the judge just saying, listen, we don't want an appeal 40 years down the road. Tell us your thoughts, first of all, about this hearing and the motions that they're arguing on each side.
I like that we're seeing the background work, like you said, but I think, lawyers like to argue. That's what we do. But in criminal law, as you know, it's a little bit different because it's not all about winning. It's about justice and truth. So if the DA used information to build their case, the defense is allowed to that information, especially like the judge says, this is a death penalty case where 4 lives were lost.
Why
play around with just that spirit of litigation and not give up discovery where you used it and they want to be able to have access to what you used to get to your point of proving what you're trying to prove beyond a reasonable doubt. I think that the DA needs to stop with the argument for every single thing in discovery and give the defense what they want, because at the end of the day, if you're using it, you're looking for justice, let them fight for their client too. That's what the Constitution says.
Boy, I so agree with you. And I can tell you, I would have so many attorneys before me when I was on the bench that would bring their arguments as to, well, we shouldn't have to give them this. But I agree with you, transparency, unless there's a valid reason not to provide it. But let me ask you this. We know this week, the case in Mississippi against the father and son, the case father and son. In that case, the judge declared a mistrial because he said, in part, law enforcement clearly did not turn over a video interview of the victim in the case to the defense or the prosecution. So I wonder if that's why now they're really focused on. The state is saying on the record in this case, Marie, hey, by the way, we gave them everything we got from the lab. We've done that. We've given them everything. Do you think now in this day and age, though, there's some questioning of, did you really?
Did you really? Because like I said, lawyers like to argue. And who are you to say what they're allowed and what they're not? Because they're building their case. They know their defense and their strategy. So if they're simply asking you for something, you don't have to make sense of why they're asking you. They have the right to build their case and keep it confidential, as long as it's not like off the chain. Let the judge decide, and I see where this judge is going. The judge is going to be very open with discovery, because like you said in that case in Mississippi, they failed to give key information during that interview to both the DA and the defense, which means no one had the chance to assess it and see if in fact it was something that was exculpatory. Maybe the alleged victim said something. If the DA had heard it, would have said, we're not bringing a charge against this father and son. Or it's something where the defense might have said, hey, we're not going to use this. But they should have been allowed access to it. Both sides, that detective messed it up for everyone.
Yeah, I don't disagree with you. All right, I know we need to get to a break, but up next, you're not going to want to miss the first witness is called talking about genetic genealogy. Stay tuned. You're watching Court TV, your front row seat to justice.
I'm not listening to either. I want to see the feed.
Tonight on Closing Arguments.
All right, I'm going to cut there from now. I'm going to go back to, oh, by the way, I updated an emoji if you guys want to check it out. Let's see. It's, let me see if I can refresh it and see if it's in there. Hopefully it's in there. Yes, new emoji there, just driving around. And I wish you all could see the photo. We got the just driving around emoji. There it is. And right on the picture, it says just driving around. It's got the middle of the street, Kohberger, the middle of the street. I don't even know why. I gotta cut this before I get a copyright. Let me go back to Guy Tenenbaum. Let's see what he's saying inside the courtroom. I don't know why would they cut out of that feed? Why would they cut out of the feed? That's so obnoxious. All right, let's go back here and look an hour ago. Okay, so let's see. Okay, back. We were in the recess, back in session. Important to note, it looks like the Gonzalez family is in attendance. Defense is calling Dr. Lee Larkin. We read that. Back on the record, state asked the court to reserve their cross-examination to consult with their own experts after looking through Dr. Larkin's PowerPoint. That's granted, which means Dr. Larkin may come back another time for more question. Presentation now underway. Wow, things are really heating up in the courtroom. We're waiting for the live feed to come back, or it won't be a live feed, it'll be a delay feed. We're just waiting on Court TV. Unfortunately, at the mercy of Court TV right now. But we'll hang out here a little bit and wait to see if there's any live tweets. If there's not, we'll just chill and we'll wait for the next bit of news that comes out. This is exciting, right? I think it's super exciting. It's like rapid fire, trying to figure everything out. We're just driving around. Everybody loves the emoji. It's great. Isn't that great? That's great, right? That's fun. It's just driving around. I wish we could see the text on it, but it does say just driving around. Let me see if I can find the I'll show you what it actually looks like when it's blown up. All right, we're still waiting the live feed to resume. I don't know if you're going to be able to see it. I can't see it. It's too small. Let me see. This is great. So I'll show you what that emoji looks like in a second. Let's go to here. Okay, I got it. This is so good. All right, we're still waiting for the feed to come back from Court TV. We'll hang here a second. Let me see. Court TV is still on a break. Let's check out Guy Tenenbaum and see if he said anything. Nope, no update tweet yet. We're gonna wait. And in the meantime, let me pull this up real quick. I'll show you what the. So this is the. I don't know why this is giving me angst. Ugh. All right. Let me pull this up. So the driving around. Let's see. This is what it would look like. Just driving around. So that's the new emoji. Check it out. Feel free to type away. And we're waiting for the feed. Court TV is still out. Guy Tenenbaum, no update yet. Let's take a look. Any new update? Nothing yet. We're still hanging here. Thanks for the hearts. I appreciate it. Wow, super exciting stuff in Kohberger in the courtroom today. Still waiting on the feed. The feed has come back. We're going to go back to Court TV. Okay, here we go. I'm going to turn up.
Apartment. You have the car. You have his parents' house that all need to be processed for evidence of the crime, and then any other evidence that comes in between now and then. I think the biggest piece of evidence that jumps out to you is the DNA evidence on the sheet. That's the one piece of evidence that will be hard to explain as a defense attorney on the case.
Let's get right back into
All
that
right,
motion
we're back
hearing
in the
for
courtroom.
quadruple murder suspect Bryan
Good
Kohberger.
stuff.
As of now, his trial is set to begin on October 2nd in the murders of 4 University of Idaho college students. They were found stabbed to death in a home near campus in November of last year. First witness on the stand, Stephen Mercer, an attorney with a specialty in DNA. Let's go back in.
We've asked the lab provided it to us, we sent it to them. At this point, all I'm hearing is speculation. They think maybe or they wish something else was there. But as far as we know, it doesn't exist. I don't know what else we can say. You can't respond to something that isn't real. Sorry, Judge.
I mean, we're just sorting it out.
Yes, sir.
Making sure that everything that there is shared. Except for the ones that you don't want to.
Absolutely, yes, sir.
And that's one of the reasons we're here.
We'll make an additional inquiry to the lab to see if there's anything else in the form of emails that they haven't already provided to us.
I would add, I mean, there are times, okay, in the world of the law, that sometimes people forget to do things, or sometimes things fall through the cracks, and so it's always healthy to make sure that it is done thoroughly.
Absolutely. Thank you, Jeff.
Thank you.
You're already called Steve Mercer.
Okay. Are your just going on? Are your experts in the courtroom right now?
Yeah.
Do they need to be in the courtroom?
Your Honor, I asked that they be allowed to remain in the courtroom, seated where they are, so they're just kind of alone.
Right. Any objection to that? I don't know who to point to here.
Sure, we don't have the witnesses excluded.
I'm going to exclude your witnesses, so they're not hearing what the other witnesses are testifying by, and that'll be, I think, a cleaner, more accurate response. So then I don't want to have them reacting to the other testimony. We'll hear each testimony, each witness's testimony be independent. And so Could you please have your other experts excluded from the court?
Where would the court like them to go? Business aid, media, in terms of environment, and I don't want them to be bothered by media and walk away.
The law library.
May I escort them there?
Sure. Thank you. Sorry, Mr. Mercer.
Thank you, Your Honor.
Okay. Thank you, Ms. Taylor. Okay, Ms. Mercer, hang on. Please raise your right hand. Okay. Thank you. Yeah, please.
Do you solemnly swear that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do. Thank you, Mr. Mercer. Go ahead and get some water there. I'll take care of that. And once you're seated, can you please state your name and spell your last?
Yes, my name is Stephen with a PH Mercer, M-E-R-C-E-R.
All right, thank you, sir. Okay, Ms. Taylor.
Good morning, Mr. Mercer.
Good morning.
What city and state are you from?
Rockville, Maryland.
What do you do for work?
I am a licensed attorney in Maryland in the District of Columbia in the field of criminal defense with area of specialization in DNA and forensic litigation.
How long have you been an attorney?
I was licensed in the state of Maryland in 1995 and in the District of Columbia in 1997. I'm also a member of several federal bars, including the Supreme Court, where I appeared as co-counsel in Maryland v. King, a DNA database case from 2013, as well as the Fourth Circuit, the DC Circuit, and a number of federal district courts.
I want to back up a little bit and have you tell me about your educational background.
So I have an undergraduate degree, bachelor's degree in English from Syracuse University, 1984. Juris Doctor JD from the District of Columbia School of Law from 1994.
And you mentioned you have a specialty in DNA. Where does that come from?
So my experience with DNA began with the first constitutional challenge to Maryland's DNA database statute, and that started in 2002 in the case of State v. Raines, where it raised a Fourth Amendment challenge to the compelled collection of DNA from convicted offenders. Prevailed on that case in the trial court. It was appealed to the Court of Appeals, which is now called the Maryland Supreme Court. The Maryland Supreme Court, in a sharply divided 4-3 decision, reversed, sent it back for trial, tried the case, and that was really the beginning of my experience with forensic DNA litigation. And then from that point, I continued in that field, attended training with the District of Columbia Public Defender Service. I began to collaborate with the Innocence Project and the Forensics Division at the Maryland Office of the Public Defender, doing indigent defense work and innocence work, and began to work closely with DNA scientists, who actually did the wet chemistry work, had numerous opportunities to tour law enforcement labs, including the NIST lab, as well as Montgomery County's lab, Bodie Technology, the FBI lab, as well. And so I continued working in the field, providing both direct representation in DNA cases as well as consultation through my private practice. And then in 2010, the public defender recruited me to head up the forensics division at Maryland's Office of the Public Defender, which is a statewide public defender system. And then there, I really dived much deeper into the field of DNA forensic litigation at that time. And if there's some questions, I can explain that further.
I may ask you some others about that in just a moment. Will you tell me about any publications, any articles that you've published?
Yes, so I published an article, co-authored an article in Maryland's DNA Databank back in the early 2000s following the State v. Raines decision. I also published an article in the NYU's Law Review about shadow DNA databanks with a co-author, Jessica Grable. And those are the principal articles with respect to forensic DNA.
And I think you mentioned a couple of professional organizations that you belong to. Are there others?
Yes, so I'm a member of the jurisprudential section of the Maryland Academy of Forensic Sciences, and I've given presentations there. For example, in 2018, I gave a presentation on proposed regulation of the field of forensic genealogy. And then I'm also a member of the National Criminal Defense Attorneys Association and a number of local bar associations in Maryland, as well as the State Bar Association.
You mentioned forensic genetic genealogy is now. Can you tell me your background related to that?
So following really the advent of forensic genealogy in 2018, that is when I had the opportunity to litigate cases, criminal cases involving that technique, the testing and the investigation related to the testing, and to receive discovery of the testing and the interpretation of the test results that were obtained through searching of genetic databanks.
You are here on Bryan Kohberger. How did you become involved in this?
Yeah, so the question was, what would a reasonable defense attorney do when confronted with DNA evidence that needs to be litigated? What are the minimum practice standards? So I'm not here to...
All right, this is all about DNA evidence and what the defense needs to do with that evidence. And remember, this is something we're going to hear testimony come up about, the importance of all of this, given this is a capital case. They're seeking the death penalty. Stay tuned. We'll get you back into this witness's testimony.
A man married.
All right, we'll wait for the feed to come back. Holy mother of God. Keep that feed up. Give me 2 seconds. I'm just doing a social media post really quick. And then I'm going to look and see what Guy Tenenbaum has for any updates, because we know what we're seeing from Court TV is on a delay. So let me see if I can do any updating here. Yeah, just take an ad break. I know they need to take ad breaks. I get it, but come on, this is important. We'll get the full feed later tonight when it's all pieced together. It's released. Okay, let's go back to Tenenbaum. I'm impatient. I want to hear it all now. All right. Defense finished up Christian Mercer back in session. Important note. It looks like Gonzalez family. Okay, we've read that. No, it hasn't been any updated tweets. 6 minutes ago. Let's see. Back on the record, state asked the court to reserve their cross-examination to consult with their own experts. We've already read this. And looking after Dr. Larkin's PowerPoint, they is granted motions. Says Dr. Larkin currently being questioned by Kohberger's defense, led by Ann Taylor. She's explaining the nitty-gritty on what genetic genealogy is, what certain terms mean, and testing processes. So we'll wait here. We're going to go back to Court TV or the live tweet feed. Good stuff. This is exciting. I love the rapid fire. It's great, right? Rapid fire here on LTL today. Turned into a great stream so far. I want to welcome and thank everybody for hanging out this afternoon. I know this was a little bit spontaneous. I kind of had planned for it, and I lost track of time and like ran home, and I was like, oh my God, I'm like a half an hour late. So we'll wait here a little bit and wait for the Court TV feed to come back. Let me get out of this tweet. I'm going to go full screen again and let's just see what the chat is up to. Tsunami says chick looks like a rodeo clown on the stream. Let's see. The person standing looks like Johnny Depp's first lawyer. Hey, Phyllis, how are you? Come on, man. Right.
Come on, man.
I hope everybody's, I hope everybody's having like a good Friday. Danielle says, thanks for doing this afternoon live. Absolutely. And then at some time tonight, I will be back to do a recap when we get the full video and we can watch the full video in its entirety without any station breaks. I get it. Court TV needs to pay the bills, but we want that feed. We want that feed. Feed. What is it? Little Shop of Horrors. Feed me Seymour. Right? Am I right? Right? The plant? Feed me Seymour. Feed me Seymour. AZ says Tenenbaum is probably in that little room off to the side of the physicary. Yeah, I don't know what that word is. Physicary. You can tell me later. Oh, I'm an idiot. I can't read. I'm terrible. English was not my first, second, or third language. All right, we're waiting here. Sky, I don't know. Psychiatry. Shrink's office. Psychiatrist's office. Is that what you're trying to say? Psychiatrist? Did you type that wrong on purpose? All right, looks like live feed's back. Let's go back to the court.
Answer not guilty pleas on each charge.
Or
Counts
delayed
1, 2, 3, 4, and 5.
Psychiatry. Thank you.
That was Bryan Kohberger's attorney speaking on his behalf back in May at his arraignment. He is facing 4 first-degree murder charges and a felony burglary charge in the deaths of 4 Idaho college students. Let's get you right back into court for today's motions hearing, which is happening inside the Latah County Courthouse. You see right here, there's a picture of it, and on the stand, the defense witness, the first witness of the day, Stephen Mercer, who's a licensed attorney in the field of criminal defense, specializing in DNA.
Never saw the
or offer legal opinions about constitutional standards. Rather, my area of focus is based on my experience, training, and expertise in forensic DNA litigation, and what a practice standards would be for a reasonably competent trial attorney who must comply with their duty to investigate the case on behalf of their client.
And is that because of what you get when you get genetic genealogy materials?
Well, yes. I mean, forensic evidence is often central on a case. And
on their website?
DNA evidence in particular. And so when there's an
Kathy,
item,
on their
for
website?
example, here an environmental sample of trace DNA evidence
I'm looking,
that,
I can't
as I
find it.
understand it from reviewing the pleadings, was twice tested, first for an STR profile.
Is it live on their website? Tsunami, can you find the link and post it in the chat and I'll pull it up?
What is the minimum practice standard for an attorney to
Or
be
someone, one of my
effective
mods
in their
maybe, post a
representation
link.
Of a client given that type of evidence?
YouTube channel, got it.
When you're talking about two
Let's find it.
happening, or two tests happening, why should an attorney know that?
Well, there are a number of reasons why it's crucial for the attorney to investigate any testing of evidence that is central to a case. And again, here it's an environmental sample of trace DNA that is being tested.
So it's not, I don't see a live.
it's essential for the attorney to know for a number of reasons about
All right. We'll stay
the
here.
details of the testing
Thank you, though.
and the
Appreciate you.
investigation when we're talking specifically about forensic genealogy. Number one
Awesome.
is
We got it.
there's
We'll stay here.
pretrial concerns. And those pretrial concerns that can be raised would involve suppression issues and potentially Fourth Amendment issues. These are questions that are very much evolving in the state of our litigation. But to understand the viability of a Fourth Amendment challenge, there has to be a factual investigation. There has to be a determination.
Okay, no problem. Thank you, Kathy.
Of,
Appreciate you. We got it.
Conduct that law
We're good.
enforcement undertook during the forensic analysis of the genealogy. So, for example, was it fast and loose? Was there searching of data banks?
Yeah, we'll stay here.
Violated the terms and conditions of those data banks? Was there surreptitious DNA collection from individuals, targeted individuals in family trees? So these are very fact-specific inquiries that the attorney must know in formulating a suppression challenge under the Fourth Amendment, because it's all about reasonable expectations of privacy. And what's really critical here is to understand, and this is close to me from my litigation, early on, the government and law enforcement's argument was always there are minimal privacy interests at stake because forensic DNA profile is like a fingerprint. And it says nothing about who the person is. But now with forensic genealogy, we're talking about genomic profiles, potentially whole genomic profiles, or at the very least a SNP profile, single nucleotide polymorphism profile.
SNAP profile.
Single nucleotide polymorphism. An SNP profile that contains a vast amount of information that is very, very private. And so this is a real game changer in the privacy interests that are at stake, and that the attorney needs to understand in investigating the case to assess and to evaluate that suppression issue, that Fourth Amendment issue. So that's one issue pre-trial. There's also concerns about reliability. And by reliability, I'm not talking necessarily about the forensic genomic profile, but I'm talking about the STR profile. And again, because as I understand it from the pleadings, there were multiple tests on the same evidence, environmental sample trace DNA. One produced a STR profile that I understand from the pleadings is represented as being a single source male profile. The reliability of that needs to be investigated, and certainly through one aspect of that is investigating the laboratory documentation that is provided for the STR testing. But we also have to appreciate, and again, I'm not.
This stats thing is kind of fucking bothering me. I'm going to be honest with you.
With experts, and I need to know what type of expert to hire.
That's I don't know. It's like when they used to put up those COVID counters, the COVID death counters.
When there's multiple tests of the same piece of evidence.
I don't like that.
That's a genomic profile. In other
a little
words,
low class.
The entire human genome that is.
Yeah, stop with the stats, dude.
Environmental sample trace DNA, or at least an SNP profile.
I don't like that.
Somewhere in the neighborhood of 700,000
cool.
locations of data.
How do you all feel about
What does
that?
tell us about the STR profile markers?
Do you approve?
So for example,
you
the
approve
STR
these
profile
stats?
markers, which are typed are 20
You approve type of 1. If you disapprove, type of 2. I'm not cool with that.
And so
Yeah, I'm not cool with
what
it.
I would be investigating with a qualified expert is, number one, and I don't know from the pleadings if there's a whole genome profile that's been developed for the
Yeah,
genealogy,
it's super
but there
tacky,
is.
right?
That should contain STR markers. What does that tell us about the reliability of the STR testing? Is there any potential for artifacts? Is there any potential
Yeah,
for
I probably
low-level mixing? mixture.
When this video goes up
Those
later, I'm
types
probably
of
going to post something
questions
on it,
that
like the
are
stats. Yeah, you need to drop that.
potentially available
I'll
to
be
acquire
vocal
and
about
ask
that.
about, where you have
I think a lot of
multiple
people are going
tests
to be
for the
angry about
same
it.
piece of evidence, and it's an environmental sample of trace DNA. Now, if it's just an S&P profile, I say just, but that's 700,000 locations of information that is like a probabilistic future diary of someone's health, medical, and all manner of conditions that are linked to genetics. That may not have the STR markers in it itself, but it will have information, S&P markers in the neighborhood of, so to speak, of STR markers that will also shed light potentially on those STR markers and the reliability of those STR markers. So these are, particularly in a capital case, crucial areas of inquiry that must be undertaken by the defense team in conjunction with experts that they've retained. But they can't even decide what experts to retain without having the discovery. And that's the minimum practice standard. And that's a point that I've made in testimony before courts where I've been accepted as an expert in Maryland, D.C., and Virginia, that the minimum practice standard is that the attorney must obtain discovery of the scientific testing of an evidence sample. And that, particularly so in a capital case, and particularly where we're talking about an environmental sample of trace DNA, it's absolutely crucial to get that discovery, because then that informs the scope of the investigation, the experts to hire, and what have you. Now, also with respect to forensic genealogy, it's important not to separate this out into all these different components.
So this is really interesting. This defense witness is basically saying to the judge, listen, these are the things you have to decide in these pretrial motions and what you're going to allow in and not on the DNA, because if you don't, it could be appealed, it could be overturned. Here's a standard of practice, judge, that you should follow. Stay tuned. We're going to get you right back into court on the other side of.
All right, let's go back to, let's do some rapid fire here. Hey, 80s kid, how are you? Okay, let's go to Tenenbaum and see what he has live tweets. Let's refresh this page. I'm going to go down. It says, Dr. Larkin currently being questioned by Kohberger's defense, led by Ann Taylor. She's explaining that he agreed. No new tweets yet. That was 19 minutes ago. Kohberger is trending on Twitter right now. It's one of the hot hashtags. It is trending on Twitter, or X. I still call it Twitter. I'm sure you all call it Twitter. But we'll wait here. I appreciate everybody hanging out on this afternoon session of the LTL podcast. We're doing some rapid fire checking between Twitter and Court TV streams. We'll have the full stream up later and do a full recap, a full playthrough without any interruptions. So we'll get the night crowd later on tonight. Not too sure what time I'm going to go at, but once this video lands, we'll come back. I also, actually in between while we do this, why don't we do this? There's been some updates in Rachel Morin. The boyfriend has come out and made a statement from the New York Post. We'll talk about this right now until we wait for that Kohberger live feed to come back up. So Rachel Morin's boyfriend, Richard Tobin, begs for help finding her. Scum of the earth murder suspect. I'll read a little bit of this and we'll wait for that Court TV feed to come back up. So Rachel Morin's boyfriend broke his silence after Maryland cops released video of the suspect in Mom of Five's brutal murder, begging for help to catch the scum of the earth. Richard Tobin, 27, demands justice for his girlfriend late Thursday while sharing images of a mystery suspect cops say was linked to killing with DNA evidence. I hope they find the scum of the earth, Tobin wrote in a Facebook update after the Hartford County Sheriff Office released the video. Justice for Rachel, RIP, I love you, he wrote along the heart with a heart and a prayer emoji. Tobin appeal came just hours after cops revealed at a press conference that a DNA sample of Morin's body matches samples recovered at a scene of an early home. And see, this is the thing that's really crazy about this, and this is what I don't understand. It's changing every time I see an article come out. First, it was a robbery. Then it was a burglary. I'm sorry, not a burglary. It was a robbery. Then we heard that it was a possible SA. Now it's saying it's a home invasion and an assault of a young girl in Las Vegas, in Angeles. So I'm not clear as to what happened in this crime, according to the mainstream media. I mean, we watched the video last night, and we were speculating and looking at it too. And I think that it was an assault of an underage girl. That's what it looked like to me. She slams the door. When we see that, we've gone back. We were kind of looping the video, making some assumptions, breaking it down. But I think that this was an assault on a young girl. We're still waiting for that court TV feed to come back to the Kohberger hearing. We're going to wait here, and we'll just keep reading through this Rachel Morin update. So it goes on here. As you know, here's the video that was, we were, looking through that, making some speculations last night. It says, unfortunately, that the suspect has not been identified, but he did leave behind his DNA. Colonel William Davis of the Harford County Sheriff Office said, based on the DNA evidence, we consider the individual in the video we obtained from the Los Angeles Police Department to be the person that murdered Rachel Morin. Davis added, I think they know who this guy is. I'm just going to go out there and say this. I think they know who he is, and they're just putting out, not releasing that name so this guy doesn't run. And maybe he has, we're going to go back to the Kohberger. Maybe he has the ability to get, out of the country as quick as possible. So, not shaking up, not putting that name out there, acting dumb like, hey, we don't know who he is, but this is the guy. And I think they have the full video of him going in and out of that house. They're just not showing it right now because they're trying to lock down where this guy is, and they don't want to scare him off. They scare him off, he's going to run south of the border, bump the border, and that's it. He's out of here. So we'll go back to the court TV hearing here live.
Standards and practices that should be allowed.
Respect to forensic genealogy, it's important not to separate this out into all these different components. It is, you have the S&P testing, and then you also have the development of these family trees, these database searching. This is all part of the same testing and experiment. They go really hand in hand, and you can't unravel them. They really have to be considered together as a single cord of different strands of the testing and experiment, because the attorney needs to know how these family trees have been developed, because we're talking now about trial issues, and the government is introducing the STR profile. They have to introduce statistics that explain the significance of any STR match that the government is identifying as central to its case. And so the defense must investigate ways to cross-examine those statistics and the rarity of that match that the government is attaching great significance to. And so an area to look into and to inquire about are the limits of the statistical tool that the government is using, or the state is using, which is based on the premise that sort of what's called a random person not excluded. And that's answering the question of the rarity of a profile in a population of unrelated people. But the key point there is unrelated. So we know there's no universe where a STR profile has no relatives. And in fact, in a case involving forensic genealogy, the way that the defendant is identified is by searching a pool of related people. And so we need to be able to investigate and evaluate the rarity of the profile within the related population. And that's a different question than what the government answers with its random person not excluded statistic that is typically used. And so, again, without the discovery of the forensic genealogy, both the testing as well as the experiments that are done with the test results, i.e. the database searches, as well as the family tree build out, the attorney can't investigate that. And in that situation, by not investigating it, is not complying with their duty to investigate that is required, especially in a capital case.
I heard you say that when you have a sample, in this case, a DNA sample from a knife, that an STR testing done, and then when you go, when you have genetic genealogy testing, you end up with whole genome testing or an SNP profile. Did I understand that?
Yes, and it's unclear to me at this point what type of genomic profile was developed, whether it was a whole genome sequence or whether it was an SNP profile, which contains about 700,000 locations of very personal, private information.
I think I heard you say that no matter which one of those were done for genetic genealogy, that you need to look at those to test the reliability of the STR profile. Did I hear that right?
Yes, so this is, as an attorney, and not a scientist, but as an attorney who has a duty to investigate, this now is an area where the attorney will look to retain a qualified expert who can evaluate and assess the linkages between an SNP profile or whole genomic profile and an STR profile. To be sure, an SNP profile or forensic genomic profile can't be searched in codex. It's not that type of situation. They can't be directly compared. But there are techniques that can evaluate if it is a whole genomic profile, you would look to a scientist who then would be targeting the areas of the whole genomic profile that comprise the STR profile to then evaluate the reliability of the STR profile, the potential for any mixture, the potential for any artifacts in the STR profile. Or if it's an SNP profile which doesn't have the STR locations in it, then you would look for an expert who understands that the neighboring regions around where the STR markers can be evaluated and assessed to provide information about what the STR markers would be.
Can I clarify something? Sure. So what you're saying is that you need to look at the advertisement, the qualified.
All right, here's what I think the point of this is. The genealogy was used, we know, in order to investigate and point to the suspect of Bryan Kohberger. Now, this expert saying, listen, how that family tree was developed, how that genealogy was used is something that we have to really do a deep dive on in order to afford him a proper defense. What is going to happen next? We're going to hit the pause button. Michael Ayala is joining me for the rest of the Kohberger motions hearing. Plus, we'll have insight from our very own Chanley Painter, who is inside that courtroom just feet away from the accused killer. Stay with us, Court TV, your front row seat to justice.
My mom signed up for AARP, but I didn't think I was ready yet until I started seeing benefits everywhere.
Join AARP now for access.
All right, sorry about that. Let me dip this feed out. Let's see. Let's see if we have any tweets from Guy Tenenbaum. All right, let's go here. Nope, no new tweets. 31 minutes ago was the last tweet. So we're just waiting. We're just driving around, right? I'm getting hungry. I might have to make some food. I'm hungry. What a weird weather day. It's like Rains, then the sun comes out, and then it rains, and then the sun comes out. Yep, just driving around. I hit the refresh. Nothing. Still waiting for Court TV to come back. Still waiting, man. Hey, man. All right, let me see. Yeah, nothing. Guy Tenenbaum, 32 minutes ago. Hey, man. I'm getting hungry. But I don't want to cut out. So Donna G says it's windy here in Jersey, but sunny. Yeah, we've had wind. We had a tornado touchdown today about 10 miles from my house here in Massachusetts, over in Rhode Island. It went through a neighborhood, flipped over some cars, flipped a boat over, put a boat in a tree. It's insane. And it came through my area. Like the tornado didn't touch down, but we had crazy winds come through. Yeah, it's crazy, right? Freaking tornadoes in Massachusetts. It's insane. Yeah, those California wildfires, man, are crazy. Oh, that little driving around. Yeah, thank you. Windy here in the UK. Isn't it always windy there, though? It's raining, too. Doesn't it rain a lot in the UK? Air is full of smoke in Seattle. It's not from the weed. All right, we're still waiting for Court TV to come back. I'm going to refresh, guy. Tenenbaum, one more time. Let's see. Tenenbaum, come through. Come on, man. Nothing. 33 minutes ago. Yeah, the old classic New England tree boat. Exactly. Come on, man. Waiting for that live feed to come back. Still nothing. Just driving around. He says, yeah, it rains a lot, definitely. Come on, man. We're waiting for the feed, man. And then I'm going to get up and make some food real quick. I'm not going to, I promise I will not eat on stream, but I'll turn the camera off when I eat. I'm starving. Come on, man. I don't want to shut the feed down. This is good stuff. Then tonight we'll do a recap. All right, Court TV back. Court TV back, man. We'll be right back. All right, let's see. Oh, they got such a cool logo. I love that thumbprint logo. So good. All right, let's go back to Court TV.
Latah County Coroner
I'm gonna go make
the identity of the four victims.
I'll be back. I'm gonna put
cause
some
and
pizza in
manner
the
of death was homicide by
Thomas,
stabbing.
I'll be back,
Shirley
man.
murders took four young, vibrant lives from our community. Nothing we do can bring them back.
And a good Friday afternoon to you. Welcome back to Court TV Live. I'm Ashley Wilcott.
And I'm Michael Ayala, and we're both here today giving you your front row seat to justice. Right now, we're going to take you straight back into the Idaho courtroom where Bryan Kohberger is in court for a motions hearing. Now, it's happening inside this Latah County courthouse. Remember, he's charged with brutally stabbing 4 Idaho college students in their off-campus home in November of last year.
Attorneys are arguing several motions today on both sides, including the prosecution's motion over the defense's alibi claim that Kohberger was out for a drive by himself on the night of the murders. Let's get you back into court on the stand. You haven't missed any of the testimony. This is the very first defense witness. Stephen Mercer, he's a licensed attorney in the field of criminal defense, specializing, of course, in DNA, which is the topic
here.
The defense wants to address first. Let's get you back into court.
And S&P profile to compare it to the SPP profile for the reliability of the SPP profile. The STR.
Only need 3 more likes to get to 100. If you're in here and you haven't smashed that like button, please do. Let's get this to 100.
Could be discerned from an analysis of the SMP or whole genomic profile. Because again, we're talking about 2 different tests of the same piece of evidence. And there have been in peer-reviewed publication, I mean, one that comes to mind is Jaewon Kim, who published in the journal Cell about how
All right, thank you.
there can an S&P profile can be linked to
an STR profile. And that's by zeroing in on sort of the neighboring regions.
Sorry, I'm eating.
And examining those. So again, I'm not a biologist or scientist, but I'm an attorney, who has a duty to investigate, and to investigate requires hiring experts to examine this data, this discovery that hasn't been produced yet. And so that's why the minimum practice standard is to get that discovery, so that the attorney can then assess that discovery and then retain a qualified scientist to help understand the extent to which SMP testing will shed light on the reliability of the STR testing that has already been done in the same studies.
Okay, so that having that profile on the SMP can verify the legitimacy of the STR.
Right, so that's my hypothesis.
Hey,
that's what I go to the
man.
expert to inquire about, because again, this is a very much an emerging area of forensic science and litigation.
Sure.
And yes,
I'm going to object again. I don't believe that this witness is qualified to comment on what's needed in these scientific processes. He just indicated that it was his personal hypothesis. I would remove my objection on it.
Well, I'm going to overrule that because I asked some questions. I apologize. Go ahead, ask your next question.
When I'm talking about either the whole genome or the SMP profile.
So let me ask you guys a question, because I'm just kind of noticing something here. Isn't this kind of like a preliminary? Wouldn't this kind of be like the preliminary hearing that Ann Taylor wanted? Am I right or wrong? If you're agreeing with me, type a 1. If you disagree, type a 2. But that's kind of what I see, like what's going on here. It's like a preliminary hearing.
but also the discovery about how the profile was then searched in different databases and family trees constructed.
That was going to be my next question. I heard you say that we can't look at this whole genome sequencing or the SMP in one category and then look at the building the tree to identify from the genetic genealogy piece, the genealogist piece, in its own separate areas, that they're not two separate lanes.
Right.
They combine.
Yes, they go
kind of like a preliminary hearing.
Or the other. I mean, they go
Yeah,
together.
it's a motion hearing, but
I'm sorry?
Can you tell me why? Can you explain why you say they go together, why you both?
Well, the SMP profile is what is searched in the ancestry database to then identify, potential relatives, and then family trees are built out. That's the object of the SMP testing. What's important to know from a defense perspective in terms of trial work and potential areas of cross-examination, the government is going to be introducing a statistic that is premised on the assumption of an unrelated universe of people. So what's the chance of finding a profile in a population where there's no relatedness between that profile and anyone in that universe? And so, as you know from talking about this whole concept of forensic genealogy, people who are related have similar DNA. And so the statistics change when you are talking about the chance of finding a profile within a related pool or related universe of individuals. And that's a legitimate area of inquiry on cross-examination for the defense to demonstrate the limitations of the statistical questions that the state is presenting to its expert witness. And to do that, you need to know.
Do you think that's why the prosecution is allowing this to happen?
Who the population of related people are,
because it's on the record.
My work on the forensic genealogy, what I've
Opinion makes a good point. It's now going to be on the record, scrutinized.
Building out.
Look at the stats, dude. Stop with the stats, bro.
And so it's important to know who hasn't been tested
Defense.
on the related person side in terms of developing cross-examination about the limitations.
Yeah,
of
Court TV,
the,
you got to stop with the stats.
Statistical
28 years old,
tool
originally
that
from
the
Eastern
state
Pennsylvania, was
uses
attending
in
school at
its,
Washington Pullman,
case to
accused of
defend
knifing
severity
4
of the
individuals to
match
death.
of legal.
Have you received genetic genealogy or
Allowing this testimony,
Yes, so
because it's going to be on the record.
which wasn't surprising to me because even though
Oh,
typically
thanks,
the government
Jessica. I
doesn't seek
appreciate it.
to
I did some
introduce the
updating
forensic
on my
genealogy,
homepage. I made a new
in
banner
this
this
case,
morning.
it
If you haven't seen it,
nevertheless
check it
is
out.
evidence that is
Your
a
picture's new, too.
scientific test of
Look at
material
that puppy.
in the case. And so the discovery rules typically call, for example, in Maryland, in the District of Columbia, call for discovery of scientific testing of evidence in a case, and that's regardless of whether the government is going to introduce it or not. DC is a little different, where it requires either a materiality showing or that the item is introduced into evidence. And so even if there's a limitation on the item being introduced into evidence,
Yeah,
that
Tsunami's
really
got the
goes to
updated
the
stats.
item tested, which here is the environmental sample of trace DNA. And of course, the government has twice tested it. And so for the attorney to be able to fulfill their duty to investigate and satisfy the minimum practice standards, they should have access to the scientific testing of that item of evidence, which is central to the case.
Isn't just 1 minute? Mr. Mercer, I don't have any other questions. I'm going to be hanging on just a minute to trust you.
Thank you.
I wonder if Taylor was sick with COVID, and that's why she's wearing a mask.
Your Honor, I have no questions for this witness, and I will be making our report.
She might have got COVID.
Thank you. Okay, may this witness be excused?
Let's welcome in at this time in Arizona, former criminal defense attorney who represented Jodi Arias, Kirk Nurmi.
Yes.
Kirk, always great
Defense.
to have you on. Thank you for joining us. This is interesting to me because here's what's happening is the defense is saying he's an expert defense attorney, specialty in DNA. And Judge, we need you to hear his testimony, and we want you to agree that the genealogy and all the statistics means that the defense has to have all this information and discovery so the court can then decide what comes into evidence and doesn't come into evidence. At least that's my takeaway. Kirk, what are your thoughts?
Ashley, I'm gonna see things a little differently and invite you to consider what we're really talking about here. When we hear words like defense, developing, cross, things of that nature, what's really at issue is the effectiveness of counsel. This might be the kind of testimony we see after somebody's convicted and sentenced to death, and they're challenged the effectiveness of counsel. What this expert seems to be saying when he talks about different jurisdictions, what have you, is, Judge, if you don't give the defense access to this information for their experts, developing cross their own case in chief, that they're going to be ineffective. That's really what we're talking about here, the effectiveness of counsel. And the defense is ultimately then trying to box the judge into a corner by saying, you have to give us this information or we're ineffective, and ultimately any sentence would be overturned on appeal.
Yeah, I agree with you 100%, Kirk, but I want to take it even a step further and see if you agree. I think what we're actually watching is the development of strategy for defense attorneys who are going to be representing folks who are being charged based on genetic genealogy. This is a new area of science. It's a new way for DNA to be used to connect people to crimes. And they're actually discovering now how to go about the discovery phase, which is all about how you deal and how effective you are as counsel. And they're developing the sort of the strategy now. This guy is an expert in that strategy, and now he's imparting to this court and eventually probably courts across the country how to go about providing information so that defense attorneys can be effective.
Yeah, I mean, I think ultimately he is describing the bar that must be hurdled, right? So the minimum requirements, what the state must do if they're going to use this information, whatever they use, they must turn over for these various reasons, the reason the expert described. Or a defense attorney is, especially in a capital case, is per se ineffective if they don't have this information. So what this expert seems to be doing, Michael, is kind of setting the standard in essence.
Would they be doing this if this was not a death penalty case, in your opinion, Michael?
Well, I think part of what they're doing here is, and we can get deeper into this when we have more time, but I think some of this is maneuvering by the defense, hoping that at some point they can get the death penalty taken off the table. I think they're taking a piece out of the playbook of Lori Vallow.
I think so too. I don't know that it's going to be effective. I understand where you're going with that, but without the death penalty on the table, I don't think that we'd be hearing any of this testimony.
Fair enough.
All right.
All right, we're going to take a break, folks. Coming up, a live report from our own Chanley Painter, who has been inside the courtroom during this hearing. She's just feet away from Bryan Kohberger. She'll have
we'll wait for that
here on Court TV Live, your front row seat to justice.
Marathon stream here on the LTL podcast today. I want to appreciate everybody for hanging out. I know that people have to come and go throughout the case. I'm getting, the sun is up on this side of the house, and you can see my windows are all blown out. So we'll do our best here to try to keep everything reeled in. We're going to wait a couple of minutes here, and then let me just readjust my camera, and then I'm going to check the live. Hang on a second. Check the live tweets from Guy Tenenbaum. I appreciate everybody hanging out. This has been really informative to get, we've been kind of waiting for some new motions and new activity in the courtroom, and we're getting to see Bryan again. Yeah, I do need some blackout shades. These actually are blackout shades, believe it or not. But it does let some minimal light in. All right, let's go to Guy Tenenbaum and see if he has any updated tweets for us. And then once my bell rings for me to put my pizza in, I have to go do that. So let's see. Kohberger is still trending. Maybe we can check it out and see what's trending. 10 minutes ago, let's see. Tenenbaum has a couple of updates here. Says defense has finished their questioning of Dr. Larkin. We haven't seen that yet. We've only seen the Mercer questioning so far. Prosecution reserves their questioning again. Judge allows them to question her at a later date. And then it says defense says they have 2 more witnesses to call, but expects Dr. Larkin's testimony was the longest one. We still haven't touched on any of their other motions set today in the document. We're entertaining an hour lunch break. Court sets to resume at 2 p.m. So it looks like they're going to get on a break, but I'm sure that the live, the delayed coverage on Court TV will continue. I'll stay with that with you all until we don't have any new information. So marathon stream today in the Bryan Kohberger case. My bell just rang to put my pizza in. I'm going to go do that really quick. But while I do that, I'll keep you all entertained with a video here. Excuse me. And we'll play this here from News Nation last night.
And this is one we've been planning. I've got another breaking story I want to talk to you about. And this is one we've been planning to cover even before this broke. And that's the case of Bryan Kohberger, a man accused of killing the 4 Idaho college students. Tonight, prosecutors challenging Kohberger's request to throw out the entire grand jury indictment. This is both sides prepare to face off in court tomorrow. Now, Kohberger's attorneys argued the grand jury indictment should be thrown out because basically the grand jurors were misled, that a higher standard of proof should have been used to determine whether criminal charges should move forward. But in this new motion filed in the past couple of hours, prosecutors say that argument, quote, rests entirely on an erroneous legal theory. They said to suggest some errors in the grand jury process necessitate dismissal of the indictment without any inquiry into the potential prejudicial effect cannot be squared with Idaho Supreme Court precedent, and that, in fact, any error in the grand jury proceeding is harmless once the defendant has been afforded a fair trial. This all comes ahead of tomorrow's hearing where the judge is expected to rule on the defense motions to dismiss the case, to set a schedule. Kohberger offered his alibi earlier this month, claiming he was going for a routine drive when the killings took place, didn't give specifics. Faces 4 counts of first-degree murder in the stabbing deaths of Madison Mogen, Kaylee Gonsalves, Xander Kernodle, and Ethan Chapin. Convicted, Kohberger could face death by firing squad because of a recent change in Idaho state law. Tomorrow's hearing is a big deal.
I can't stress it enough. It's going to dictate when the trial happens, if the indictment gets thrown out, and how the defense is going to defend themselves. So I don't know where you want to start. If you want to
start with the defense.
Let's start with the defense. Their main goal, let's just try to throw out the grand jury indictment. You and I talked about it, talked about the standard of proof. Prosecution responded very strongly. So since you and I talked, I looked at Idaho law, and there seemed to be confusion about what is the standard of proof by which a grand jury has to come back. Prosecution said whatever ambiguity there is, you look at the Supreme Court, and they have been consistent, it is probable cause.
They're going to lose. The defense is going to lose.
Okay, so put that to the side. The defense has a stronger argument that they say the prosecution has to turn over to them evidence regarding genetic genealogy. The most important piece of evidence in this case is that DNA linking him to the crime scene. They say, we want to know.
Court TV is back. We're going to pull that back up. Give me a second here. Oh, man, I tell you, they need to update. Come on, StreamYard. Multiple media tab.
That's right. That's exactly what we've been watching. And we know that this judge is not letting us live stream the hearing. So as we get portions of that hearing so that you can see it in its entirety, we are bringing it to you. So while we have an opportunity, we want to bring in live now Latah County Courthouse Court TV legal correspondent Chanley Painter outside of that courthouse. Chanley, rather, and tell us, so, you know, I noticed the judge is asking questions. He's seemingly very engaged. I know your description earlier, the defendant had an awkward smile as he kind of walked into the courtroom. Tell us all of your impressions since you have been inside that courtroom with him.
Well, it's a pretty full house, Michael and Ashley, filled with media, some community members watching this hearing unfold. The parties, of course, and the family of Kaylee Gonsalves, who walked right past our live shot into the courthouse earlier today. Her mother, Kaylee's mother, telling me that they're optimistic about the day and the judge's decisions that we hope to hear later this afternoon. Inside the courtroom, like I said, a pretty packed house. It was essentially silent as we waited for everything to start, and we had all eyes on the door where the accused mass murderer would walk in. He comes in, as you probably can see on your screen, with a gray suit and a tie, and gives this sort of awkward, slight smile as he looks up towards the gallery and down. It was a very weird moment, but it was noticed by everyone in the courtroom, especially the victim's family members. I noticed Kaylee's mom, Christy, turn to her sister sitting next to her and kind of roll her eyes and shake her head that defendant would dare to even make any sort of expression inside the courtroom. And there was another moment that unfolded with a witness, the second defense witness of the day, where Ann Taylor, Kohberger's defense attorney, had some trouble working the technology of the PowerPoint, and the judge said, well, maybe we need another expert to show up inside the courtroom. Everyone sort of chuckled, including her client, the defendant. He gave another little smile there, but he's showing more expression today than we've seen in previous hearings.
Chanley, what were some of your takeaways from today's testimony? I mentioned earlier that I think this is really, it's becoming a very important issue, and as it's used more and more in courtrooms across the country, in DNA as far as genetic genealogy. This is almost setting a standard for what defense attorneys need to look for and ask for in discovery, as well as in cross-examination. What are some of your key takeaways from some of the testimony we heard this morning?
Absolutely, Michael. This doesn't surprise me that the defense team here is challenging literally every step of this process, because I'm sitting in the courtroom and we all know that they took a cheek swab of the defendant, and it's a perfect match. Why are we going through this process of how this genetic genealogy investigation unfolded? Well, that's because the defense wants to challenge every part of this investigation, right, when we know the foregone conclusion. But still, here we are today. It's probably why the prosecution hasn't cross-examined any of these expert witnesses thus thus far today. But what has been standing out to me is that this is a defense who wants to make sure they obtain every part of what the investigators did last November, December in trying to solve this crime so that they
He's
can
got a
hire
weird
their
walk, huh?
own experts to
I feel like
analyze that same type of data.
bro walk
So
where
to
he
give them
sticks
some
his chest
fodder
out.
for cross-examination of any witnesses
used to make
during
fun
a
of those guys
trial.
in
So
high
they're
school.
asking for this judge to compel prosecutors to turn all of it over because prosecutors say we're not even going to use it. It's not really relevant at this point, and we want to protect the identities of the hundreds of people who were brought up and to build this family tree. But I'd say, even though it kind of could be a little tedious with experts, it's really fascinating if you're into DNA evidence, Michael, inside the courtroom, because these experts are really teaching the judge what's out there in this science.
And it is a new area, and so this expertise is something I think future attorneys are going to look at, rely on, as this is, I think, the next stage of evidence that's going to be presented. All right, Chanley Painter, thank you so much for joining us live. We do want to get you back in the court again. You haven't missed any of it. The second witness is on the stand for the defense. This is Dr. Leah Larkin, a genealogist.
No, they're not there.
Surely you should have had somebody besides you.
We need another expert.
And there was that comment about the PowerPoint presentation.
I think we're ready now. Yes. Now, are we going to talk about how genetic genealogy works? Yes.
I'm just going to turn the volume down. There's not much action going on right here, but I just want to make a comment again. You know, bottom line for me, it comes down to, and I think when you hear a lot of this, the experts that get on and talk about what's going on in this case, the bottom line is the defense can challenge as much as they want. And I've said this and just in the generic term, it's going to come down to this. The defense is going to have to account for that knife sheath being on that bed with Bryan Kohberger's DNA on that button snap. They're going to have to explain for that. As much as you want to try to get rid of this DNA evidence, and this is what I laugh at about all the people that doubt the DNA evidence. If this DNA evidence wasn't relevant in this case, why does the defense continue to attack it? Why does the defense continue to erase it? Because they know that they're going to have to account for a knife sheath with the defendant's DNA on it laying or placed or under a cover, whatever way you want to say, next to, let's just say that, two murdered individuals in that house. You're going to have to account for this. You know, this whole driving around thing, just driving around, and ironically, the one white Honda Elantra out that night without a plate on it that's been spotted in multiple areas around taking this trip gets spotted in and around King Road. And how ironic that when everybody gets up in the morning, there's 4 dead individuals in this house and there's a knife sheath with his DNA on it laying next to 2 of the victims. You're going to have to explain that. That's why they're attacking this. This is why I want people to wake up to what's really going on in this case. And these channels and these creators and these people that create articles and podcasts to try to point you in a different direction, they're wrong. They're wrong. They're doing it for clicks and views. This is, I think when we get down to the nitty gritty and we hear that opening statement from the prosecution, I think this is going to be a lot easier to explain than all the conspiracy theory that has surrounded this case. Because bottom line, it comes down to this. The defense is going to have to account for this. This is why they're trying to get rid of it. I promise you. That's why they have all these high-powered experts coming in to try to challenge it. Okay, sorry. That was my rant.
Judge just showing me heritage patterns of the Does the autosomal DNA stuff provide more matches so that you can do your work easier?
Yes.
How does this happen? How do you get to do your work?
Okay, so if you're just a regular old genealogist, you will purchase a DNA kit from one of the main testing companies. They will send you a little tube, and you either spit in the tube, and it seems like a lot of spit, Or you do a cheek swab, you put that back in the tube and you mail it back to the company. The company will then extract the DNA and do the analysis on it.
We like to do it in real time if we can, Jenny. You know, I was home today. I had the opportunity to pop on here, do a little bit of a marathon stream. And, you know, once the video drops tonight, we'll be back probably live tonight and, you know, do some recapping and kind of hang out and take it down to a, you know, a lower level, and we can kind of pick apart what's going on and recap it. So.
German stock or Scottish or African or, you know, whatever your sort of
That's absolutely right, Cindy. And that's their job. That's their job. That's what Ann Taylor is hired for.
People who've taken the same DNA test in the same database and who share DNA with you. Yeah, so that's the two main things that you get from that.
So the same database, what do you mean by that?
So there are multiple companies that offer these services.
Oh, excuse me.
So the two biggest ones are Ancestry DNA and 23andMe. So
yeah, it's pretty lame. This I gotta say one thing about Court TV. Don't do the stats. It's not cool.
Because we're not in the same database.
Where you test is specific to where you're going to claim who you're related to.
Right.
Okay. All right. You as a genetic genealogist, the cases refer to you?
Little insensitive.
Yes.
Okay. And so how do you get into these databases?
So at Ancestry DNA, there is a sharing system. So the person who's taken the test can essentially authorize me or invite me to view their DNA results, and then I can do that in my own account. I never have to log into their account. At the other services, with the exception of GenMatch, which we haven't gotten to yet, I would have to log into their accounts to see their DNA matches.
You mentioned that, you're backing up a little bit, but you mentioned that you can find out a lot about your ancestry, meaning kind of where you come from. What other types of information can you find out?
So, for example, at 23andMe, they offer health reports and trait reports based on your DNA that can tell you if you have a higher than average likelihood of developing certain cancers or certain diseases. They can tell you things that are kind of silly, like do you like cilantro, or if you're prone to drinking more caffeine than the average or less. But they can tell all of those things from the DNA test that they've done.
And that's only
Thank you, Olivia.
23andMe does, and then there's a third-party site called Prometheus that you can take your
Come on, man.
and upload it there.
I got you, homie.
Bing, bing, bong, bong, bing, bing, bing.
PROMETHEASE. And if I got that wrong, it's not because I'm lying.
You changed slides.
Coming up, more live testimony as the witness breaks down the science behind DNA. That's right on the other side of this short break. Stay tuned.
All right, commercials. And there hasn't been any updates from Guy Fieri. No, it's Guy Tenenbaum. We'll wait. I smell my pizza, though. I'm going to eat that. I'm not going to have the camera on when I eat. I won't be rude. But let's go back to, yes, pizza time. Let's go back to that video I was playing.
Know how you came to this.
All right, let's back up a little bit.
And there seems
I love Jesse Weber. He's awesome.
Defend themselves. So I don't know where you want to start. If you want to
Let's start with the defense.
Let's start with the defense. Their main goal, let's just try to throw out the grand jury indictment. You and I talked about it, talked about the standard of proof. Prosecution responded very strongly. So since you and I talked, I looked at Idaho law, and there seemed to be confusion about what is the standard of proof by which a grand jury has to come back. Prosecution said whatever ambiguity there is, you look at the Supreme Court, and they have been consistent, it is probable cause.
They're going to lose. The defense is going to lose.
Okay, so put that to the side. The defense has a stronger argument that they say the prosecution has to turn over to them evidence regarding genetic genealogy. The most important piece of evidence in this case is that DNA linking him to the crime scene. They say, we want to know how you came to this. Who else did you identify?
If I showed you the size of the pizza, you all would be like, what the fuck? Because I'm on Nutrisystems. I've lost 11 pounds in the last month and a half. I feel great. And when I'll show you the pizza, you're gonna be like, that's what you're eating. I'm down to about eat about 1,000 calories to about 1,200 calories a day, but I'm down 11 pounds.
What
So
were the methods
happy.
that you used?
Feel
We have
great,
a
by the
right.
way.
This is part of the discovery process.
Not
Now, what's the
vegan.
prosecution saying? Well, wait a second. You don't have a right to know if we looked at John Smith or what other names came up. It's going to, hurt the integrity of investigative methods. You don't have a right to it. Now, what do I think is going to happen? The judge is going to go somewhere in the middle, because this is a right for the defendant to defend himself and try to say genetic genealogy, as strong as it is, we have a right to poke holes in it. But to go into so strong that the defense has a right to say who else was identified and what were the methods that investigators used, I don't think the judge is going to allow that.
The defense has also added another DNA person to the team.
So they've added a DNA expert. Yeah. That is probably going to counter the prosecution's expert. I mentioned DNA before in the other case. As strong as genetic genealogy is, and we've seen it solve a ton of cold cases, there are holes in it. It's when you take something like 23andMe versus a lab conducted test, it's not always the same. And they're going to fight that. And they have to, because again, it was first his father's DNA that was matched.
Right.
And then once they got him, they took his own DNA and it was
I gotta
a
go grab my
statistical
pizza.
match.
Shit,
So they
hang
have
on.
to fight. Now, if the
Right
judge, let's say, says, you don't have a right to any of this, then that is going to impede the defense in a major way. I don't know how they're going to defend themselves.
What are we talking about in terms of timing? Are they going to be setting any schedules?
Yes. So this trial is set tentatively for October. His defense team is trying to stay it, basically pause it. I don't think this trial is happening in less than 2 months, okay? This is a death penalty case. There's a lot they have to go through. Is it so shocking to think this might get pushed out to 2024? I don't think so. And so there's a part of it where it's ultimately going to be up to Bryan Kohberger. If he says to his attorneys, listen, I said a speedy trial, I want this to go to trial, it's his choice.
All right,
But
does
his
everybody want to
attorneys right
see
now
my
are saying, we
pizza?
want to pause to this. We want to review the grand jury. We want to see if there were any problems in the grand jury process. They noted that. They said that there was problems in the grand jury, the way that they filled out the questionnaires. They said that there was problems in the way that certain statements were made in front of the grand jury. So they want to pause in it. But look, it's going to be up to him if he says he wants to.
Yeah, if the defense had a stronger case,
Yeah.
I would think they might want to rush this to trial. I think right now time is on their side. They want to try and find any potential flaws, mistakes.
Thanks for hanging out on the stream.
You don't believe I was just driving around in the middle of the night.
I mean,
driving around. There it is.
That's not an alibi, right? I mean, an alibi.
Hey, I'm down 11
means you
pounds. I feel
actually
great.
Have some sort of proof you were somewhere else. I mean, I guess you could call it an alibi, but an
driving
alibi
around.
typically says,
Throw
"Oh,
that driving around
I was at
emoji
the
up
store,
there.
and I've got a
In the
receipt
chat.
that I was at the store." And I was driving around by myself isn't much of an alibi. And thank you for watching.
All right.
Go to News Nation now.
Let's see if we got Court TV back. All right. Let's see. Court TV's back. Let's pull that back up. I'm going to eat while we're watching that.
That's a statement to me.
Right? Exactly.
Yeah.
Oh, I was by myself.
Like, how do you,
Driving
I'm
around.
driving alone. How do I bring somebody in to testify to that?
Right. Well, the cell phone data, but I think that cell phone data arguably gets him close to the home where the murders occurred. All right, let's get you back into court right now. Still talking about genetics. That's the topic of the day. This is the second witness discussing this, genealogist, Dr. Leah Larkin.
So a microwave is the actual piece of lab material that they used to run this test. It was designed, so microarrays were designed for biomedical research. They're designed for scientific research. And unlike the STRs that you use for POTUS, microarrays pretty much scan your entire genome. They're looking at, so we talked about autosomal DNA. They look at about 600,000 individual bits of your autosomal DNA. Those are called single nucleotide polymorphisms.
Yeah, that's what I do, Jet Set. Yeah. It's so good, though.
And then BOLYMORPHISM. I feel like I'm in a spelling bee. These are individual bits of DNA that are known to vary among people. Most of our DNA is identical, so looking at those bits are not going to tell you who's related to whom. They look at these microarrays specifically target the chunks of DNA that we know vary between or among individuals. And so that uses higher levels of DNA than you typically have for forensic purposes.
Doing more like when you talk about spitting and tumor swatting, you have a lot of it to do this.
You have to have a fair amount of DNA to do a microplate.
What happens if you don't?
Then there is an alternative. There's an alternative method called whole genome sequencing, and this is there's whole genome sequencing, and the specific way they go about it is called next generation sequencing. And that will actually work on lower levels of DNA. It will work on lower quality DNA, so DNA that might have been broken down because it's been exposed to elements for a while. That will work better on DNA that's contaminated. So it might have bacterial DNA in it or fungal DNA in it. So that is an alternative approach to microarrays, but it's more labor intensive and it's more expensive.
So you either microarray or this other way that's more expensive and sounds like more issues with.
Thank you.
To get to something that you can put in your computer and find out who you're going to be.
Yes.
What is this?
So, this is just kind of a teaching strategy just to show that we have 2 parents, 4 grandparents, 8 great-grandparents, and I've color-coded the grandparent
Stop
lines,
with the stats,
to help
Court
us
TV.
track
This is pretty
how the
disgusting.
matches fit in.
And when you do autosomal DNA, it's this group of people that you're drawing.
Those are the people who contributed the DNA in you, yes.
What do we have here?
So this is an outline showing how some of your DNA matches might fit into your tree. So you may have some second cousins or first cousins once removed or second cousins once removed who also took the DNA test and are in the same database as you. And they would share DNA with you and would be listed in your matches. And you can see that in this diagram, I'm only showing
healthy, though.
2 great-grandparent lines.
I don't
There
eat
are
a lot of
actually
junk
4.
food.
The diagram gets too messy if I try to add more. So the thing is, when you get these matches, the DNA company doesn't actually know how you're related to them. It just knows how much DNA you share with them. And so the DNA company is not going to tell you, this is your second cousin. It's just going to say this person shares so much DNA with you, and they could be your second cousin, but they might could be something else. And then it's up to the genealogist to essentially reverse engineer the tree based on the DNA matches.
Do you do that when you have to find out who this person is based on these various matches in different places?
Right.
Do you have experience as a genetic genealogist doing that, where you don't know who this person is, you got to identify this person based on their kit?
Yes.
So what do you do?
So you will get a list of DNA matches from your testing company. And they are sorted, that list is sorted by how much DNA they share with you. So it's not necessarily sorted by how closely related those people are to you. You get this list, and sometimes they use their real names, the people in the list. Sometimes they use an alias. Depending on the database, you may or may not be able to see their email address.
That thing is
and some of them
pretty low
will
class.
have their own family trees
I gotta
linked
say, I'm
to their
a little.
DNA results because they're doing the same thing you are. They're trying to research their family trees. A lot of them won't.
Still with us, Kirk Nurmi. All right, Kirk, tell us what you think of this testimony. And Michael, I want to turn to you first, though, because again, another DNA expert, I think it is cutting edge, learning about what the standards should be for defense attorneys.
You know what's being raised for me, and Kirk, I want to bring you in quickly on the conversation, is one of the things being raised by the defense is the reasonableness of the search, right? Because at the end of the day, when you talk about what they're doing here and the expectation of privacy, those are all issues that are raised by what's going on here. And it really sort of hit home to me as I'm listening to this witness testify about all the different levels that this DNA testing can connect with, and the fact that they just tell you how much you share with this person, not necessarily how they're related to you.
Right. I mean, I think we put this together with the first witness and saying why you would be ineffective. Now, this witness scientifically is talking about the methodology, the conclusions that could be drawn from it, and why the defense needs to investigate the validity of those conclusions.
Really good.
And so, again, going back to the idea and what Ashley said before break, I don't think this inquiry would be happening as wasn't a death penalty case. But this evidence is the most powerful evidence against Mr. Kohberger, and therefore the defense is well taken to lay out the steps that they should be doing, advancing in order to provide a proper defense. And this expert is detailing some of the things that make it the case that this is just not a foregone conclusion. They can't just accept the state's word for it.
But why is the state fighting it as hard as there? We know, go back to the earlier discussion about, listen, if you're the state, why not turn everything over and let them decide what their defense is going to be? Why fight it as much as they are?
You know, that's what I don't understand, because in a death penalty case, they know that the defense attorneys are entitled to this information, particularly in any case, frankly. But in a death penalty case, the scrutiny just becomes heightened all the way. I could see their concerns about privacy, some of the people that have put their names into the database, things like that. That can be controlled. That can be restricted to a protective order. But why the state is fighting this, to me, it doesn't make a lot of sense.
The only thing that I can think about is I think a lot of what they think the defense is doing, Kirk, is trying to buy time. They're trying to not toll or not give up their right to a speedy trial, yet get more time. So if they can prove that they have to do more work in order to figure out the issues presented by a couple of different things, the grand jury and the DNA, they can tell the judge, look, we don't want to waive our speedy trial rights, but we're going to need an extra month just to kind of figure this out. Because they did that already with the grand jury issue and got 37 extra days, which angered the prosecution. They're arguing against it. Your thoughts?
Yeah, but when the state made the choice, and it's completely the state's choice to charge the death penalty, they have to understand that death penalty counsel has to be prepared for the case. So this idea that this is going to be some kind of speedy trip down a conveyor belt to place Mr. Kohberger on death row is simply not a viable belief. So this idea that, you know, they're going to withhold this evidence, you don't need it, you're going to take more time. No, that's not really what is at issue here. It's not speed, it's getting it right. And the defense is telling the judge why they need this to, in fact, do it right.
And I will say, I love that they keep saying it's we don't want to appeal in 40 years. They do have to be really cautious. And I think it's the right thing to do because you want to prevent an appeal as much as possible. Kirk Nurmi, always a delight. Thank you so much for joining us today.
Yeah, great stuff today, Kirk. Appreciate it. Folks, coming up, the expert says it's possible you could have a first cousin that shares less DNA than a second cousin. It's interesting stuff. We're going to hear about that on the other side of the break. Keep it here on your front row seat to justice.
All right, we'll bounce out here for a second. Let's look at Guy Tenenbaum. Montana. So Tsunami says, question, where would you rather buy a house? Flathead Lake, Montana, Sun Valley, Idaho, or Sedona, Arizona? Jeez, man. Definitely not Arizona. Too fucking hot for me. I like the change in season, so I probably would say Montana or Sun Valley, Idaho. But Montana's beautiful. I've been through there a long time ago. No, I'm not promoting Nutrisystems. I wasn't promoting. I'm just saying that that's what I was eating. That's the plan that I'm on. It's just like if I was drinking Gatorade. I'm not promoting Gatorade, but I'm drinking it. You know, I'm drinking Poland Springs. I'm not promoting them. If they want to reach out and promote me, if someone wants to sponsor me, I'll take that sponsorship. I'll be your spokesperson. But yeah, you know, I was just saying what I was on. I said it once. It wasn't like I kept going, go eat Nutrisystems, do Nutrisystems. I'm on Nutrisystems. It's fine. You know, it's a meal plan. It helps me get regulated. I lost 11 pounds off it. I wasn't saying that. It's just basically calorie counting. Their meals are like 200 to like 250 calories per meal. And then you get some snacks in between. So for me, like if I'm not on a regimen like that, I tend to gain a lot of weight and I eat a lot of crap. So I don't think it was that big of a deal. I was just talking about it, just driving around. All right, let's see here an update on Guy Fieri. I keep saying Guy Fieri, Guy Tenenbaum. Yeah, they're in a break. That's why we're getting what we're seeing on Court TV, on the Court TV. An Amway category? What's Amway? I think I know what it is. Oh, multi-level marketing. I'm not doing Richard Simmons. I just wanted to, get my weight back down. My weight was getting high. God, my background's all blown out. What is a pyramid scheme? What is a pyramid scheme? A diet that works? Your mom knew Richard Simmons? Holy shit, that's crazy. All right, enough about diets. Everybody's getting mad about this diet thing. All right. Court TV, not back yet. Oh, let's go back to this really quick in between. Let's see. So we were talking about Rachel Morin. The boyfriend had stepped up and started speaking. It says the video shows a shirtless suspect during the front door and walking down the steps of a now it's saying burglarized Los Angeles home. He was described as a Hispanic male in his 20s who weighs in around 160 pounds. So, and 5'9". I think, and like I was saying before, this was someone that probably hooked up with an underage girl that walked into that house, either wasn't supposed to be there or kind of got into the house, had an essay, and then was forced out of there because, as we looked at the video, it looked like he was getting pushed out the door. Court TV is still on a recess. They'll be back in a moment, but we're just talking a little Rachel Morin. Nothing new as far as an update. Man who claimed a stepdaughter, Morin's friend, persons of the body appeared to be the victim's head smashed with a rock. Jesus Christ. Before she was dragged into a drain tunnel, leaving a long blood trail behind. Police have not confirmed that account. Jesus. That's probably the drain. It's just so sad. Her naked body and severely battered body was discovered in a tunnel along with the Ma and Pa Heritage Trail. Jeez. Oh, boy. All right, let's see if Court TV is back. They're back in court.
About their DNA. Yes. That it doesn't tell you how closely related some of this.
Right. So we measure autosomal DNA in a unit called centimorgans, centimorgans. The more centimorgans you share with someone on average, the more closely you are related. But it's possible, for example, there's a range for most of these relationships. So it's actually possible that you could have a full first cousin who shares less DNA with you than a half first cousin. And that's one of the things that complicates the work of a genealogist. We only have an approximate relationship from the centimorgan mill, not a hard and fast, this is definitely so-and-so relationship.
In your work, when you have your unidentified person and you put the profile in and receive matches in various places, you're looking at these centimorgans to try to get a clue. What do you do after you have this information that tells you about centimorgans?
So I have to essentially build trees for these matches. The first step in the process is to figure out how they are related to one another. Before I can figure out, for example, if I'm trying to help an adoptee find their biological parents. To figure out how they are related to their matches, first I have to figure out how the matches are related to one another. And then I kind of reverse engineer where my adoptee will fit into that family tree based on the DNA results.
What does that side tell you?
So we mentioned earlier one of the tools that I helped to develop for analyzing DNA results. This is a set of screenshots from this shared centimorgan tool. It's also sometimes called the shared centimorgan project tool. That's too many syllables. So what you do is you will type in the centimorgan amount for one of your.
Can I pause this? It's a little boring here. I want to pull this up because I just saw this. Check this out. From News Nation, posted about an hour ago. Let's listen to this.
Jesse Weber. Jesse, welcome back. You joined us yesterday to talk more about the two motions set to be argued from the defense, but as Alex laid out for us, we know that there are also 4 from the prosecution. What stands out to you from the prosecution side?
Yeah, first let me just say excellent reporting by Alex. I've been following his Twitter feed all today. He's giving us an inside look on what's happening in that courtroom. Well, their motions are kind of tied to what the defense is arguing regarding a protective order regarding the DNA evidence. So it's related to what the defense wants. So the defense wants more information about the DNA. The prosecution says, no, there should be a protective order and certain material should not be shared over with the defense. And then, of course, there is this question, and happened last night, where the prosecution fought back against what the defense said a few weeks ago. As we recall, the defense said that the grand jury indictment should be thrown out, that the grand jurors were instructed improperly, that there were problems in the grand jury selection process. Well, the prosecution responded yesterday and said that is not the case at all. If you look at the Supreme Court law, under Idaho Supreme Court law, it is very clear what the standard should be for a grand jury. They were instructed properly. Even if grand jurors mistakenly filled out something wrong on a questionnaire or left something out, that is not grounds to throw it out. So they are trying to go full steam ahead and make sure this trial happens and happens on time.
All right, so Jesse, we know the defense wants a stay in this trial, at least a delay. The prosecution, though, is arguing about maintaining Kohberger's right to a speedy trial. So we have this back and forth. If this doesn't start in October, as it is currently scheduled, when do you think it's likely to begin?
So it's tough to say, right? Imagine the defense gets everything they want. Imagine they say, they convince the judge that there were problems in the grand jury selection process and they need to investigate it a little bit further. Let's say they're handed over all of the investigative methods behind genetic genealogy. That is going to take time for the defense to go through. And I've said it before, I will say it again. I wouldn't be surprised if this gets pushed off into 2024.
100%.
Will that happen? Your guess is as good as mine. But I just don't see this trial happening in October with so many outstanding issues. And of course, this is a death penalty case. Getting a jury in such a high-profile case in that jurisdiction
100%.
and a death-qualified jury, I think the jury selection process could take weeks in and of itself.
Yeah, I mean, the fact that we're also talking about not one murder, but 4. So Jesse, let's talk about alibi here, because right now the defense is saying Kohberger was driving around that night, but not claiming to be at a specific location at
I'm telling you, they got it from me.
So is this really a
Throw
plausible
up those
defense?
driving
Is my
around
question.
emojis.
He was
Let's see him in the
somewhere,
chat.
but we won't tell you
Every
where
time we
nor
hear
when.
driving around, you throw up those
It's
emojis.
a defense. It's not quite an alibi. The way I understand it under Idaho law, and the reason the prosecution has been really holding the defense's feet to the fire, is because if you're going to say that,
Throw that
you need
driving
to
around.
show
There it
where
is,
you
Gary.
were,
I love it.
what time you were there, and any corroboration.
Love
Do you
it.
have any supporting documentation, surveillance tapes, eyewitnesses that saw you at this
Driving
place,
around.
records, financial
Telling
records,
you, they
phone
got it from
records,
me.
anything that can point you there? And the defense hasn't said that. So it seems to me, I could be speculating, that maybe Bryan Kohberger told his defense counsel, yeah, I wasn't there, I was driving around, but he hasn't really given them much to prove
like a
that
drinking
at this
game.
point. Now, they have indicated in the past that they'll show his alibi by cross-examining some of the state's witnesses to show that he really wasn't where the state says he was. But I think today is going to be important to get a little bit more clarification on the alibi defense, and if the defense has to show anything more in order to prove it.
All right, and just Jesse, before we let you go, there's this
Yeah, I'm
DNA
gonna-
evidence
I'm gonna probably
which,
clip
you
the
know, we know
Razor
that the
Ramon.
defense is arguing about, the prosecution is really pushing. But what about the phone records? And there's
Thank you for the
also that
2
surveillance
299
video. I mean,
pounds.
isn't some of that going to be difficult to
I
refute?
gotta get that. The
Okay,
Razor
so
Ramon.
putting the DNA aside, which again I've said is the critical evidence, the phone records and the surveillance footage is so important because it's going to be very hard for Bryan Kohberger and his team to explain away why he was in that area, why he was near that house, why he was driving that car, again, assuming it was him driving the car at those high rates of speed. And we know that later on in the day, there is surveillance footage of him exiting that very car. Now, of course, he could say maybe he was out late driving, maybe he was visiting the bars. It just doesn't seem plausible based on everything that we know. But hey, let's see what happens in trial and then try to argue against it. But I think it's going to be very difficult for them.
Yeah, we will certainly see what happens. As always, Jesse Weber, we certainly appreciate your time. Thank you. Thank you for watching. Go to News Nation now.
All right. All right, let's see if they're back to court. They're on a break in court. Let's see if there's any new tweets. Yeah, the defense is driving around the courtroom. Court TV still on a break. Let's see if Guy Tenenbaum has any updates. I think they're still on their hour lunch. So let's go back to Guy. They're still in a break, but we're getting a delayed feed through Court TV. So we'll give it a couple more minutes. So Claudia is saying, what are you talking about? Driving around was in the court documents. They did not get it from you. What do you is a way of saying it, which they did not use it. Well, I'm talking about the vernacular that I use when I say just driving around. And I found it very interesting that when I started doing those streams before the mainstream media was really talking about this driving around theory, that the tone and the vernacular that they were using in their voice was the driving around. You know, that became kind of a joke here on the channel. So that's what I was talking about. We know that it was in the court documents, but I'm talking about the vernacular that I was using, the tone of the driving around. And I find it very funny, and my audience finds it very funny that that became a thing with the mainstream media. And they do watch these smaller streams. You don't think that they don't have people that are watching these streams, mainstream media? Of course they do. Of course they do. News outlets watch these streams because we'll talk about things and then all of a sudden it's on mainstream media. So that's what I was talking about. The tone of the voice. I got to clip that Razor Ramon and get that skid mark in there. That'd be great. I think they're still on a break. Let's go back to Court TV. Court TV says they'll still be back. Hey guys, we're marathon streaming. If you're new in the chat room here, you just came in, come on, hit that like button. Let's get some likes up in here. I appreciate everybody hanging out. I mean, we're going on almost 3 hours. 3-hour stream, marathon stream today. We're just driving around. We're driving around. We're just driving around. Driving around. I unfortunately have to run out in about an hour, so I gotta go get my laundry. All right, let's see if we can cut this up while we're waiting. Court TV back in session. We're gonna bring up the feed. Let's get the driving around.
Kohberger walked into the courtroom, half smiled, and she explained that it was
Real
more
creepy.
of a curling of his lips at the gallery, and then took a deep breath when the hearing began.
The first witness to take the stand was Stephen Mercer. He's a criminal defense attorney who specializes in the use of DNA evidence. Now, he testified about the impact and validity of the DNA evidence found in this case. We continue to bring that hearing to you. We're bringing it all to you. We did hit the pause button, so you won't miss any of it. Let's get you back into court with the second witness for the defense, Dr. Leah.
Do they show Amway commercials?
And this graphic shows us the process and how far you have to build trees for the matches and try to identify the one person. Did I understand that right?
Yes, this is just a simple example where I've built out two hypothetical trees for two hypothetical matches. In which case, in this example, I've gone out to the first great grandparents.
What are you looking for?
I'm looking for connections between match. So match 1 is on the left, match 2 is on the right. I'm looking for commonalities between their two trees. I want to see how match 1 and match 2 are related to one another. And so in this case, I've identified, and this is hypothetical, of course, that John Smith and Mary Jones married and had children, and they were the great grandparents of the person on the left tree. And John Smith and Mary Jones were also the great grandparents of the match on the right. So now I know that match 1 and match 2 are second cousins to one another. That's kind of the first hook that I have into trying to figure out how my person of interest fits into that tree. And so I would then diagram.
What are you doing from there?
Yes, thank you, sorry. I would then start building what I call a descendant diagram, and I will do this in a sketching software. So I have John Smith and Mary Jones, and I've listed their 2 children and their grandchildren. Then I put the DNA matches in there so I can see how the matches are related to one another.
Let me see if I understand this. You took matches to your unknown person and then built their trees out and found great grandparents that were the same great grandparents
Yes.
to both these other matches to the unknown. Is that right?
Yes.
Okay. And then you took that match and started figuring out who their kids were, and then each of their kids had kids. Is that what we're seeing here?
Right, and so what I'm looking for now, so I found these 2, match 1 and match 2, who are second cousins to one another. What I'm looking for now are ways to integrate more DNA matches, okay, into that tree that I've just got my hook on.
Why do you want to do that?
Because the more DNA matches I have, the stronger my statistical analysis for where my person of interest fits into that tree. So if I'm working an adoptee case, my goal is to get my adoptee into as many databases as possible. I always call it tested ancestry because that's the biggest database. Then 23andMe because it's the second biggest. And then my heritage is the next in size. And so I want to get them into all of these databases because I can do this. I can build this tree using the sub-matches from Ancestry and the sub-matches from 23 and some from my heritage. And again, I'm doing this so that I have as much statistical data as possible when I try to place my personal interest into that tree.
Driving around. That's great.
It looks like you replaced the people, the matches.
I think I got it.
Yes. Those may be hard to see, but in this case, I'm showing an example listing the centimorgan amounts to the various DNA matches that I've managed to place.
Did we hear it? I got it. I love it. Just driving around.
It's an educated guess
great.
about where my person of interest might fit into that tree based on how much DNA they share with those 5 matches that I could document. And it might be right, it might be wrong. It's just an educated guess. It's a way to guide my next step.
A Razor Ramon theme.
My next step in the research. At this point, you might need to dig into another database and see if I can find more matches. I would run the what are the odds analysis tool to see what other hypotheses might fit.
You want to tell me about the what are the odds tool now?
Sure, I can. That's a different slide.
Oh no.
So this is the what are the odds tool. You basically build the the descendant diagram that was on the previous slide, but into this tool, you enter the centimorgan amounts, so that's the measure of shared DNA. You enter the centimorgan amounts into the WATO tool. Sorry, we call it WATO for short, WATO. And so you enter the centimorgan amounts where those individual DNA matches fit into the tree, and then you can ask the tool to suggest possible hypotheses for you. And that's what those teal boxes are. Those teal boxes are places where the tool is saying your person of interest could fit into this tree in this spot, based on the DNA matches.
This tool tells you kind of where to look.
Yes.
In that line. What do you do from there?
So from here, there are several hypotheses there. If you could go back to the previous slide. Thank you. There are several hypotheses there, so what I want to do, and each one of them is going to have a score. And so what I want to do is focus on the hypotheses that have the highest scores, because those are the ones that are most likely. And I might investigate whether I'm looking for a birth father, was he in the right place at the time of conception, or was he serving overseas? If he was serving overseas, then I rule him out. I might reach out to members of his family and ask them to do a DNA test for me, because then I can add their DNA match to this analysis and sort of slowly over time focus in on my most likely candidate, for example, if it's a birth father.
Does that mean you reach out to just the regular people that haven't chosen to do this and see if they voluntarily want to put their DNA in to help build a family tree?
Yes, at times I will do that.
I think we're ready for this slide.
Okay, so it's the same tree, but I'm showing a different scenario in which the DNA matches were lower.
Oh,
they
wow.
shared less DNA.
Real quick, I'm gonna give you an update tweet because I'm getting a little snoozy here on this. I know it's very important, but so Guy Tenderbomb says back in courtroom post lunch break, waiting for court gavel to back in. I wouldn't be surprised if these proceedings go on for several more hours with how things have gone so far today. Wow. Crazy. Yeah, I might have to break in a little bit because I do have a couple things that I need to do today, but I definitely will pick this back up a little bit.
Some genealogists call it target testing, some call it strategic
I'm noticing
testing. You're essentially reaching
a lot of
out
people are
to
falling off.
who haven't tested yet and asking
But
them, hey,
maybe we'll come back with a part
for
2
me,
in a little while
and you're
when I
doing
break
that
off
to
in a little bit.
help narrow down
See, I had a
the
million
connections.
people. I'm gonna hear about that shit all the time now.
This one has some what's going on.
Right, I'm afraid you can't see the scores on that tree because it's kind of small. But those arrows are pointing at the hypotheses in this tree that have the highest scores. So that's where I would try to target relatives who might be willing to do a DNA test for me.
And those scores come from the tool.
Those come from the tool, and they're
and those give you, I guess, information about which direction is more likely.
Yeah, the probabilities are based on the shared centimorgan amounts.
We're going to shift and talk about forensic genetic genealogy. Tell us what you mean by that.
So forensic is basically pertinent to any sort of legal proceeding or court case. I'm not a lawyer, so I'll talk about that wrong. But in this case, sometimes so the Department of Justice calls this work forensic genetic genealogy. A lot of practitioners call it investigative genetic genealogy, but it's the same thing.
Does that mean it's work that's done for law enforcement?
It's work that's done for law enforcement, and it's also done, oftentimes I think the client might actually be a medical examiner if you're dealing with an unknown who remains.
Do you do that kind of work?
I do not.
Have you been taught about that?
I have learned a bit about it, yes.
How have you learned?
I've learned about it by communicating with practitioners who do it, and also by attending conferences and watching recorded videos.
Did you do it if you wanted to?
Yes.
There's no other call.
We do need to take a break. Her testimony was in part that you ask people to do genealogy tests in order to help narrow down the connections. And people do these tests all the time, Michael. So I have to ask the question, do you think that potentially if you take the test, you forfeit your right to privacy?
A lot of that, Judge, would depend on what you sign before you give it over. There's always these things you have to sign, when you do these. So whatever the wording is in that, I would imagine it's different for different sites. But generally, my answer would be yes. I would imagine that they have a right to, in those agreements, to use the results and what you give them, and they become public. And it's not like a HIPAA or something where your health records are protected. I don't think you're certainly not protected to that level at all.
And I would say, too, read those documents closely, because I agree. I think what they say is going to control at the end of the day.
Yep, no question about it. All right, we'll take a break. Get you back into the courtroom on the other side.
All right. Back on a breaky dakey. Breaky dakey. All right, let me see here. We'll go a little bit longer here, and then I do have to step out. I have to get I gotta go get my laundry. I got a couple errands I need to run. But I appreciate everybody hanging out. I mean, marathon stream. I think this is probably the longest stream that I've done. But I can pick this back up in a little bit if I go off air. 3 hours. 3 hours in the chair. We're banging it out. 3 hours in the chair. 3 hours. I appreciate everybody for hanging out. We might need a little break here in a bit and then come back and see what we can pick up a little later on. 3 hours in the chair. Banging a marathon stream, man. My back windows are all blown out. Better go for a drive for a while. Yeah, maybe I'll take a little drive. All right. Let's see. Let's see what Madam Ruby sees. Remember that? Pee Wee Herman? Just driving around. Let's see what Tenenbaum says. Anything from the tender? Okay. We got a couple more posts for 7 more hours. He says 3 minutes ago, we're back on the record. Defense has called another genealogist from California, Gabrielle Vegas. Ann Taylor with the defense said before the break she expects to call one more witness in addition to Vargas. Sorry, I said Vegas. I meant Vargas. Vargas says that she's self-taught based off her previous experience searching for family members, which led her to starting a website to help others trace their lineage. Oh boy. I don't know how that's going to go down, but we'll wait here. Thank you so much, Carrie. I appreciate you. Thanks for hanging out. 3 hour banger today. We'll go a little bit longer. I don't have to go quite yet. Maybe we'll do a little while longer. I'll take a break. We'll come back and try to pick up, kind of where we left off, because it seems like this is going to go for a while today. We'll give the stream some time to breathe a little bit, and then we'll come back for like part 2. I got to get up and stretch here in a minute. All right. Nothing yet from Court TV. Let me see if we have another live update. Idaho 4 is trending on Twitter, and Bryan Kohberger is trending on Twitter. So both those hashtags right now are trending on the Twitter or X or whatever you want to call it. Nothing yet. Court TV still out on a break. Yeah, absolutely, Danielle. Thanks for being here. Appreciate you. That's so great. I'm glad I thought of that. Danielle. All right. Nothing yet still. Let's refresh. Tenenbaum. Still nothing. No tweet yet. Court TV says it's going to be right back. We'll go back to the feed. They're probably going to come back here in a minute. Station break. Thank you, Court TV, for your coverage. We appreciate it to allow us to do what we are doing today here in the Bryan Kohberger motion hearing. You see a 3-point turn coming up.
The motions hearing for the defendant in the Idaho student murders case is still going on.
Bryan Kohberger is accused in the brutal stabbing deaths of Madison Mogan, Kaylee Gonsalves, Zana Kernodle, and Ethan Chapin, and this happened last November.
And if you're hearing static in the feed from court, well, we now know, we can tell you that's from a giant fan. So there is a little hard to hear because of that. But we want to get you right back into the courtroom for more testimony from the second witness, Dr. Larkin, who is a DNA expert.
The slide talks about the kind and quality of DNA. What kind of DNA is needed for forensic DNA? What kind of DNA?
So you can use any type of DNA the same as you would use for regular genealogy. You could do mitochondrial, you could do like chromosome, you could do autosomal, and as I mentioned before, most of this work is using autosomal DNA. The difference is that if somebody's spitting in a tube, they're providing a lot of DNA, and they're providing clean DNA, and they're providing DNA that gets preserved with a fluid to keep it from breaking down. And that's not always the situation that you're going to find at either crime scenes or if you're dealing with unknown human beings.
So now we talked about the microarray a while, and that there was another way to get this profile to do your work.
Yes.
Is that where we're going?
That's where we're going.
Tell me about that.
Okay, so next generation genome sequencing is a technique that you can use to analyze the entire human genome. You're not just focusing on the 600 or 700,000 bits that the genealogy company uses. You're trying to sequence the whole thing. And that can sometimes work when there's not enough DNA for a microarray.
How is that done?
It's hard to explain. So I'm using this graphic to try to explain it. So imagine that the solid red line at the top is the entire genome that we're trying to analyze. Next genome sequencing actually focuses on little subsets, and it's kind of like skimming a document. Or if you skim a document, you're not reading every single word. Next generation sequencing is not trying to read every single little bit of DNA along the way. Instead, it's skimming little bits, and it's missing a lot on the first skim. And then it skims it again, and it will miss some on the second skim, but it might pick up bits it didn't pick up the first time. And so it keeps skimming the DNA, and after the analysis is done, you can kind of reconstruct from the little snippets that you skimmed along the way, and you can post the next gap. So these are the portions in Prey that were skimmed in the multiple episodes, and those are called reads in the next generation sequencing process. The more reads you do, the more of the genome you can reconstruct, and the more confident you can be that you did it correctly. Because sometimes if you're skimming a word, you might, the word might be there and you read there because you were reading too fast, right? So the more times you skim an individual piece of DNA, the more confident you can be that it was called accurately.
Is there a number of times that's practice skim?
So for medical research, for biomedical research, the companies who sell this equipment recommend that you do 30 times. They call it a 30 times coverage to get a confident read. Oftentimes in forensic work, they're not able to get 30x reads, and so they're working with fewer skimming. Not skimming is not a technical term. I'm just using the analogy to teach this.
We talked about missing information when you skim. This slide says that it's filtered by a word called imputation. Is that what this slide means?
So if you can't do 30x coverage of the genome, which is often the case when you're working with low quantities of DNA or contaminated DNA, you won't get the whole genome. You'll be missing pieces. This is a stage of the process called bioinformatics. And you actually have a specialist who goes in and uses statistical methods to try to fill in the pieces that were missing in the initial analysis.
Does that mean that person's projecting what would be there?
Yes.
That's showing us that?
That's showing us the parts that were imputed. That's the term that we would use.
All right, once you have this information after bioinformatics has added their details, then what happens?
So recall that the next generation sequencing is analyzing the entire genome, but the genealogy companies, the matching databases, are not interested in the entire genome. They're not going to analyze the whole genome. They only want the
this is Larkin.
So the SNPs that were analyzed by the microarray. So now the bioinformatician has to go in, essentially delete a whole bunch of the whole genome data so that they're only left with the portions that would have been on a microarray had they done microarray in the first place.
And this happens after they're filled in to make it whole, but they're stripped back to make it usable.
Yes.
Genetic genealogy database. How do you know if you're not just left with all of those filled in things?
I'm sorry, I don't quite understand the question.
So when these are stripped back out so that they're usable, so they become an SNP, which is usable. This is after the imputation.
Right.
How do you know?
How do you know which parts were imputed and which parts were from the next generation sequencing?
Yes.
The bioinformatician would have access to that data, but as a genealogist, he wouldn't know.
Okay, that question would be for somebody different.
That would be for someone different.
After the SNP is created, then
you have a file that would look just like what you could get from one of the actual genealogy testing companies, and you can upload that. If it's a forensic kit for forensic purposes, you can upload that to two main databases. One of them is called Family Tree DNA, which in the trade we generally just call F2.
DJ in the house. What's up, dude?
And there are a couple
3-hour marathoner, bro. 3-hour marathoner going on. I'm just getting tired from sitting because I don't normally sit this long, so I'm kind of like, and I had that pizza, so that carbs are just sitting in my stomach. I'm like, I'm falling asleep.
all right, on this slide, does this represent most of these companies that do the genetic analysis?
Those are all of the main companies. There are
And frankly, this DNA stuff's a little boring to me. I do have to head out in a little bit though, but I'm only going to be gone for a little while, and then I'll come back and fire up the stream, take a little break. 3 hours, man.
And what does all of this really mean? Let's bring in criminal
nothing.
defense attorney, former prosecutor Franz Borghardt. Fridays with Franz. I'm going to steal your moniker because you've always called it Friday with Franz.
Our Fridays
It
with Franz.
is our Fridays with Franz. But tell us, Franz, what you think of this testimony. I was saying if a jury was there, it can be a little tedious, but this is in front of the judge as part of a motion.
So it's either junk science or defense smoke and mirrors. Take your pick. I think DNA evidence is pretty well established as not junk science. This genealogy business, That's got us
Finally,
all
an
scratching our
expert I
heads.
agree with.
There are constitutional issues around it. There are issues with regard to its validity. I'm just not convinced that this judge is going to exclude it. I think the safer answer is, well, this is an issue for the trier of fact, that the jury can weigh whether or not it's good or not good in terms of its quality, its admissibility, and what weight to give it. So I mean, it's a great attack by the defense. I just don't know that I've heard anything yet to convince me it's nothing more than, like I said, smoke and mirrors.
Right.
Franz, the judge and I have been discussing here when we're off camera. Why do you think the prosecutors are fighting this so much? This is a new area. There's a lot of information that needs to be passed over, but they're fighting, saying some of it is work product, some of it is not relevant. They're fighting this. Why do you think they're fighting it when it's a death penalty case? You should err on the side of giving more rather than less so that there are less issues on appeal.
So if I were prosecuting this case and they wanted this information, I'd absolutely give it to them because it is a death penalty case. This is not the one to not disclose something, not to give something over, because at the end of the day, what you don't want to see happen, Michael, is you don't want to see this guy convicted, him given the death penalty, and then a higher court somewhere says, you should have given him this stuff. And the court didn't, by saying that we agree with you, the court basically will be in a position to overturn a death penalty. I agree with you 100%. Give him the stuff, give him everything he wants if you're going to try to put him to death.
And I just, again, at the end of the day, I think the defense is smart. I think they're coming up with any argument they can think of. This is a fairly new expertise being developed and what they need to ask for. But again, going back to discovery, I agree. Give it to them. Give it to the defense and let them do with it what they will as they're building the defense. One other thought, and that is everybody wants a look at Kohberger, and we're getting a look at Kohberger, and he really doesn't have much expression other than a little bit of a smirk and a chuckle at one point. And I think that we need to take a break. But Franz, super quick, how much does his demeanor matter in these motion hearings?
All potential future jurors are watching. I just assume and live my life that everyone's watching court TV and that they're all watching, and anything he does, any smirk, any smile, any smug look could be used against him in the future. And so if I were representing him, I'd have the poker face on. There's no winning facial expression, right? He's accused of a terrible crime, but the smirks, the smug looks, those aren't going to help him.
Yeah, and from your mouth to God's ears, all of the potential jurors are watching court TV.
Yeah,
that would be ideal.
That
would be ideal. All right, we're going to take a quick break. When we come back, folks, we're going to get you back into that courtroom as they begin to wrap up the testimony of Leah Larkin. She's a forensic genealogist. So keep it here on your front row seat.
So, like I said before, and I might take a little break here. I'll come back in a little bit. I'm sure there's a million people streaming right now. But if you want to continue your coverage with me, I'd appreciate it. But, going back to just what that gentleman was saying, is this all smoke and mirrors? I think it is. I've always said this all along. And the bottom line, it comes down to this. Okay. Bottom line, it comes down all to this. It doesn't matter, in my opinion. It doesn't matter that it doesn't matter of you arguing where this DNA came from, how they got it. The bottom line is this: it's in case evidence. And the bottom line is that the defense is going to have to come up with a defense to prove that this was staged, that it's not Kohberger's DNA. And I've said this before, if this was and we've said this a million times, a nothing burger, then why is the defense attacking this and trying to get this DNA evidence thrown out? Bottom line is this: Bryan Kohberger's DNA was found on a knife sheath next to, around, under, however you want to put it, according to whatever PCA, however all these conspiracy channels try to throw it all to you, that his DNA was on that item next to those two murdered girls. They're going to have to explain for that. That's the bottom line. That's why the DNA is pushing for, the defense is pushing for delays. That's why the defense is trying to get this DNA thrown out. That is the bottom line here. It doesn't matter. You're going to have to explain. If this water bottle has my DNA on it and I have no connection to ever being in and around someone's house, and this bottle of water is next to a dead victim on a bed with my DNA on it, and that gets processed, I'm going to have to explain, or my defense team's going to have to explain how that got there. That is the bottom line. If I've had no connection to that house or whatever, an item, whatever, you know, that's why they're trying to get this DNA evidence thrown out. They're using smoke and mirrors to do it. So that's what this comes down to. There should be no explanation. There should be no item of Bryan Kohberger's in that house. There shouldn't be, according to what we know about this case so far. He had no connection to these individuals. All we know is that he's been driving around. His white Honda Elantra was caught in and around that murder scene. And ironically, the next day when everybody wakes up, that the sheath that covered potentially the murder weapon is found on, near, or around, however you want to look at it, a bed with 2 dead victims. You have to explain for that. You have to explain for that. I don't think they can. That's why they're challenging it. And I think there's a shitload more evidence out there that the defense is completely scared about right now. That's why they're trying to attack this DNA. That's why they're trying to cast out right now. So that's the way I look at it. That's the way I'm seeing it. We'll wait a little bit more here from Court TV. I'll play a little bit more, and then I do need to run out for a little bit. I got to run out for a little bit, grab my laundry, and we'll come back and do another stream. I'm going to take a little break. All right, we're back at Court TV. Let's pull that back up.
The Idaho student murders case is still underway.
On the stand now is genealogist Dr. Leah Larkin, who's testifying about how they collect and use DNA to create profiles.
Absolutely.
Get you right back into court.
Per the terms of service of the companies, they're only allowed to use family tree DNA and GenMatch, and there are 2 smaller dedicated databases. One of them is called DNA Justice, which has, as of yesterday, about 500 people in it, and the other one is DNA Solves, which is owned by Optum, and I have no idea how many people in it.
Those 2 that you just talked about, can anybody use those, or are those only law enforcement?
DNA Solves and Courtroom. Yes, those are only for law enforcement. A regular genealogist wouldn't have access
Tsunami
to
says, I can see the judge throwing out the sheep DNA, and then the prosecution introduces biological DNA of Kohberger at Kohberger's, I think, at the scene, or Kohberger's, Kohberger at the scene. Could be.
Those are usable.
I just don't.
Both of them existed.
I just don't see Judge throwing any of this out. As important as DNA evidence is in a case, I mean, DNA has exonerated people. DNA has convicted people. So I just don't see him throwing this out. I don't see it. I don't see where he's going to turn and say that. This is just another, I think, tactic from the defense to slow things down, to continue to slow things down. But I do think that, like the experts are saying, the prosecution just give it up, because later down on an appeal, a higher court, like they said, may say, hey, you didn't give them this, and it creates some complications on appeal.
But for both MyHeritage and Family Tree DNA, you could test directly with them, but you could also take your data file from one of the other companies and just upload the file. And it's just a text file that has thousands and thousands of lines of DNA data.
So as a genetic genealogist, you are working with somebody and you can take their profile and make it come true and put it in MyHeritage and Family Tree DNA.
Yes.
And you also put it in Gen.
Yes.
And law
Exactly.
enforcement can only search Family Tree DNA and GenMatch. Can they search your person?
If there's a DNA match to my person, they will see that match.
Okay. Does your person have to agree to law enforcement to let that happen?
If we're talking about my adoptee, so it's complicated because the rules have changed continually over the past few years. As it currently stands at GEDmatch, if we were to take a brand new kid, a brand new adoptee client, and upload their data to GEDmatch, we would have to consent. The client would have to either consent or decline to consent to participate in law enforcement matching.
If they decline to participate in law enforcement searches GEDmatch, then they should not see your clients.
They should not see my clients.
Okay. Same with family tree DNA.
Family tree DNA, the system is kind of the inverse. If you add a kit to family tree DNA, they automatically opt you in. There is a way to opt yourself out, but you kind of have to know where to find it. It's not obvious.
Again, a person can keep their information private, so it doesn't wind up in law enforcement searches.
They can, yes.
Family tree DNA. And my heritage is different, law enforcement shouldn't upload.
My heritage explicitly prohibits it.
Could I just ask you all questions that related to the arrows?
No. So the database, the total database at Family Tree DNA and the total database at GEDmatch are both larger than the number of people who've opted in. So not everyone at Family Tree DNA has opted into law enforcement matching. Not everyone at GEDmatch has opted into law enforcement matching. And so the arrows are the gray bars are showing my estimates. And these are my personal estimates for the number of people in each of those databases who are officially accessible to law enforcement for matching.
And that's because those companies have
I did it.
Yes. I think we're now to the last section where we're going to talk about the work.
I just did it.
Genetic genealogy.
Hang on, I'm going to show you.
What is that topic?
See if I get a response.
So these are the
I just tweeted at Court TV. I'm going to show you real quick. Right here at Court TV. Quit with the baseball stats, on-screen graphics of the victims and the suspect. We'll see if I get a response. I think it's a little low class. I'm going to go out there and say it. It needs to stop. It's a little disgusting, you know. No need for it.
The one on the right is what a typical match list looks like at Family Tree DNA. For my plans, I will actually screenshot the matches and put that in the text to my report. I also copy all of the matches into another program.
I got a light.
Because sometimes people will,
we'll see what happens.
They'll be in the match list of my adoptee.
Yeah, it's a little low class, you know.
And so I like
no
to
need for it.
That, hey,
I mean, I respect Court TV, what they do, but the baseball stats, little insensitive. Little insensitive to the situation.
So much DNA with my client.
I hope they take that tweet into consideration.
It does look like a family tree, and it's anonymized.
It's bothering me. And if I was the families, I would be a little pissed off as well too.
So this is the family tree that I would have built for my client.
Like this stuff, we don't need to see this. A 20-year-old triplet was dating Xana Kernodle, attended frat party with Xana prior to the murders. Like we don't need to see that.
If I was able to find the family, the census, immigration records.
I mean, even the stats for Bryan Kohberger, we don't need to see that stuff. We know. Everybody knows.
Obituaries, if I find them, if I find family photos, a lot of times you might find articles in the newspaper, and I will link everything.
Yeah, no problem, Lakota. I appreciate you. I'll put it out there. You know, it needs to stop. It's a little insensitive.
Yes, it helps verify that all of the relationships that I'm reporting to them are documented and yeah.
And it looks like you gave them a copy of the descendant diagram.
I did.
and give them a copy of the letter of the odds. Okay. And a written report.
I do. If the client requests it, I will write a report.
Other than those things that you give your clients, what would be available on the forensic side of the genetic genealogy?
Right, so they should have.
A couple of programming notes about this hearing that viewers have asked. Number one, we are not able to live stream. That was part of the judge's order, so we're bringing this as we get it into you. Number two, we cannot train the camera on the defendant, so that's why you're not seeing the defendant the entire time, but rather the witness. And number three, we know it may be a little bit tough to hear. That's because there is a fan, a giant fan, causing some static, so that's the reason for some of the issues with being able to hear. But keep it trained here because we're going to get you back into court on the other side of a short break.
All right. 3.5 hours with you all. Thank you so much. It's been a great stream so far. Long stream, probably one of the longest that I've done in my career on YouTube. Let's see if Guy has any updates, and then I'm going to bounce out probably for a little bit. I have some errands that I need to do, and then I'll come back and try to catch what we can, the rest of the stream here, because I'm sure this is going to go on for a while. Thank you, Carrie. I appreciate you. Okay. Vargas, we're back on the record. Defense has called another genealogist, Gabriela Vargas. We've read that. Vargas says she's self-taught based off her own previous experience searching for family members, which led to her starting a website to help others trace their lineage. Now, I want to know, was it just one DNA experience that she, tracked down and solved, and then this website launched, or is this a multiple of records? Does she have a track record of tracking down things like this? And then Vargas says she was asked to speak to the defense by someone in the field based off her previous experience working different investigations with law enforcement. Okay, so she does seem a little bit of a track record. I'd be curious to hear her expertise. Again, I'm not going to slam anybody because I am not a DNA expert at all. Let's see. John says, jurors hate sitting through this type of testimony. It's going to be horrible and boring for all of us. I had a trial that had 3-day alone on the DNA related testimony. Judge was nodding out. Yeah, that was a big thing in the OJ case as well, too, where it was very technical, and it seemed that they lost the jurors around that as well, too. Let's see. I got Frankie saying, I think it's extremely poor taste of Ann Taylor wearing the same mask that Kohberger is alleged to have worn that fateful night. According to Dylan, she could have worn another color. Yeah, I mean, I think you have a little bit of a point there. Sure. We'll take that into consideration. Thank you for voicing your opinion, Frankie. Thank you, Danielle. Appreciate you. Just driving around. That's all we're doing. Yeah, I got to drive around in a minute. Let's see. Court TV is still out on a break. We'll wait here a little bit more. Maybe we'll go back to some of the testimony here. Still out on a break. Tenenbaum with no updates. Let's see. Nothing yet. 24 minutes ago was his last tweet. We'll go back to Court TV here. They said they're still out on a break, and we'll wait for the feed to come back. If not, I'm going to take a little bit of a break, and I'll come back at some point. I already have the second marker up. We'll take a little break and come back. I mean, we're not going to solve anything here yet. I think it's going to just be more DNA evidence, or testimony.
Welcome back to Court TV Live. We're here with Judge Ashley Wilcott, and we are in Latah County, Idaho, for a hearing involving Bryan Kohberger. Now, the name I'm sure sounds familiar. He is charged in the murder of 4 college students back in November of last year. This hearing is involving a number of issues, not the least of which we've been hearing about most of the afternoon, involving DNA. Why is it important? Why are we here? Well, if you remember, there was DNA found at the scene of the murders on a knife sheath. Now, they went to the home of the parents of Bryan Kohberger, went into the garbage and found DNA. They ran that DNA, matched it to what they had from the scene, and then put it into a DNA database, one of those 23andMe type sites online, and it was a direct match for his father. Now, again, that's called genetic genealogy. It's sort of a new approach to connecting people to DNA. So what are the rules for defense attorneys in terms of what they're able to go in and find out about how that was done, how it's done in terms of how they're going to cross-examine any experts on this issue? Privacy issues are involved as well. Before we go back to court, I want to bring in criminal defense attorney and former prosecutor Franz Borghardt. And Franz, what I want to ask you is, as a practicing attorney right now in the field, this is a new area, this genetic genealogy. Is it taking hold amongst the defense bar? Are you finding it necessary to educate yourself on this? Are there continuing legal education classes that are helping attorneys get on board with this type of technology and what's going on in this area?
So this is the frontier, right? This is the next wave of how law enforcement is going to do its job. And so we are starting to
CAST is going to be very important in
get
cases
courses
now.
on it in terms of continuing legal education. We are starting to try to find DNA experts that have dealt with this, which is problematic because the only DNA experts that have really dealt with this, Michael, are those who work for the government, who work for either state crime labs or labs that work with the federal government. So it is, I use the word frontier because it is kind of a new thing. It's here to stay.
Actually, I'm not bald.
And with
I just
any
shaved my
kind
head.
of new analysis, there comes this urge to figure out how can we attack it? How can we assault it? You know,
I say it all the
goes
time.
hand in hand with another DNA test,
I
right?
came
It
out
just
of the room with
leads
a
you
hat on.
down a rabbit hole so that you know, well, look, we know that there's a familial relationship,
that's
so we know
pushing
we
it
need to do
forward.
additional testing. So yeah, it's here to stay. We're trying to learn about it, but it's new stuff and we want to get the data. And that's what his defense team is wanting to do.
Yeah, it's a fascinating
Bald as
area,
fuck.
really. And it's a lot
I
of
don't
testimony
care.
to absorb, but it's really important for the court to understand it, to make decisions about what all.
I talked about that before, dude. If you're bald, just embrace it. Who cares? And the funny thing about it is, too, if you look at, what do they say? Some of the most sexiest men in Hollywood, what do they all have in common? They're all bald. I don't give a shit. I'm bald as fuck. Just own it.
Or
Like, trying to hold on to your hair is worse. Just let it go.
I need to give that to my client because they had that when they came to me. There are some complications when you're dealing with forensic DNA because I didn't have a person's
I got a nice head.
DNA for two. Sometimes you might have a mixture where more than one person is represented in the sample. So that needs to be analyzed, and there presumably would be documentation.
Hey, it's easier. I don't have to comb my hair when I get up in the morning. I love it.
CONVOLUTION. If there was not, if there was non-human DNA contamination mixed in with the sample, sometimes, and not always, sometimes they will do what is called enrichment, where they're trying to increase the proportion of DNA that is human.
No comb overs.
If that process was done at the lab, there should be a record of it. The bioinformatics that we talked about, so imputing any missing data and then stripping out all of the non-genealogical DNA points, all of those there should be records of.
Oh, I think you have logins or Twitter numbers.
Right. So when you have, once you've gone through all these steps, you've done what we call the wet lab work, where you're actually doing working with the samples, and then you've done the computer analyses. You end up with the output file that mimics. It's like a fake microarray file, right? So it mimics the data that we would have gotten from a genealogy company. GenMatch and Family Tree DNA both charge law enforcement to use their database, and so there should be some sort of contractual agreement or receipts that you paid the company for the upload. And then there are logins, because for you to be able to see the matches, you have to log into that account. You have to have access. You have at Family Tree DNA, you have to log into that specific account. At GenMatch, I believe you can give access to a few different researchers, but they have to know what's called a KIT number, which is the youth identifying number for that KIT.
When you said a fake microarray, it reminded me that when we talked about microarrays, you told us that those contain a ton of personal medical information.
Yes.
This also has all of this?
Yes.
And do you, because there's so many more, I guess, people or kids or profiles in our territory, is that a place that somebody that can try to match might want to go?
Yes.
Dr. Martin, thank you. I don't have any other questions, but don't leave quite yet. I'll pass it to Mike.
Thank you. We need cross-examination. Okay, thank you. All right, may this witness be excused?
Yeah.
Okay, if you're excused, you can...
All right, we are going to bring back in Franz Borghardt as we're still watching this. And again, we were talking a little bit while we were watching that testimony, Franz, the reality of why this is important. Because if, in fact, there's any grounds to attack the underlying testing or information, you can try to get thrown out all of the touch DNA from the fingerprint, the blood, all of, I mean, that's where at the end of the day, it's the rubber meets the road, so to speak.
So why all this fight? Well, let's not mince words. The state is trying to put this guy to death, and he is entitled to a constitutionally sufficient, adequate, whatever word you want to use, defense. But in a death penalty case, it's no holds bar, right? And you're absolutely right, Judge, is if there's a break in the chain, if there's anything in the link between how they got the initial DNA all the way to where it leads to them, then it might be excludable. And if it's excludable, what happens? I mean, think about what happens to the state's case at that point. It would be a suppression under a constitutional basis. And, you know, it would be like hitting the state's case with two giant torpedoes. This is huge. This is a huge facet of the case. And so, of course, they're attacking it. And something y'all talked about earlier is, again, I agree. Why not give them all this information? Why not let it be vetted and litigated so that once it can be decided upon, they can move forward? If you're going to try to put him to death, I think you have to do that.
Franz, let me ask you this question. Let's say there is a problem. I don't anticipate that being the case, but there is a problem, and you have to throw out the fact, because without the DNA there and this whole process, then there's no connection to the sheath. Then you don't arrest him. So what happens at that point? I mean, clearly they know that he's connected somehow. What happens at that point if, in fact, it is thrown out?
Well, they can either continue and steamroll forward with the prosecution, which I don't think they would. I think what would happen is they would take an appeal, Michael, and fight all the way up to get that evidence back in, or they could wait and see if they can get future evidence. You know, just like this is a new scientific frontier for us, using a very innovative method of collecting data and using that data, they, I think, would wait to see if they could get additional evidence. So, but I agree with you. I think it's going to come in.
Right. All right. Franz Borgart, thank you so much for being with us on this Friday. Always great to have you. And speaking of this Friday, what else do you have coming up?
Yeah, all right. You have a fantastic weekend,
Thank you.
folks. You'll be sticking around because we're going to continue to follow the Idaho student murders case. A new genealogist will be on the stand when we come back on the other side of the break.
That's who I want to hear. I want to hear Vargas. We'll hang out a little bit longer here. I want to hear Vargas speak. I do have to go in a little bit though, and I think it would be a good time for a break for everybody. But we'll come back. I'll come back tonight. Rip up a stream. Still nothing from Tenenbaum. How's everybody doing? Everybody good? Everybody good? We're going almost 4 hours. 4-hour banger. 4-hour banger. I got nothing back from Court TV tweeting at them about that. Everybody's good. That's good to hear. What's everybody else doing? Tanya's streaming. Hey, Tanya.
I'm wondering if they
Watch
couldn't
this. I'm going to
upload or do the
What?
3 unidentified male matches. I wonder if they could do where it was like they could get the sex of the match on the DNA, but they couldn't get like a full profile. Does that make sense? Like to where you could run it. Yeah, you can. Yeah, you're not gonna be able to get away with anything with all this technology. I mean, there's just so much. Cast, cell phone pings, his car, like the cast stuff, the DNA. It's just hard to be able to get around anything.
watch it.
I can hear my dogs making some noises, so I might have to take them out. Vincent's usually home by now, but I think he's bringing me some food home too.
Let's see if she says anything.
Oh, okay. Thank you. You taking a break? I feel like I need a break. I'll have to. I just said I'm gonna have to get me some. I'm gonna have to get me some food. We've been streaming for 4 hours and 30 minutes, but we do this over here sometimes. We like the court dates, don't we? Except for when they're boring. Today's a boring day. I ain't gonna lie to y'all, but it's I'm because I'm a more visual person.
All right, I'm gonna get out of Tanya's stream. All right, I think this is a good pause for a break. I do want to hear Vargas's testimony today. I think that's important. That's probably something that I can find. I do have some personal things that I got to get to, but maybe we'll fire back up in an hour or two. They're gonna post all this online anyway. I'm sure it's probably getting posted as we are speaking. So I think this is a good time to get everybody a break. The views are going down. So everybody, it's like dinner time for everybody. But we can pause and come back tonight. I think that's a smart thing to do right now. East Idaho News is chopping it up. So all the parts will be out there. We'll chill on it for now. We'll come back. My eyes need a rest. I've been looking at a screen for I've looked at 3 screens for like 4 hours. You can probably see my eyes are getting tired. But this is a good thing, good break for everybody. We'll drop out. I'm probably going to come back live in about an hour or two. I'll set up the tile for you guys. Hopefully we'll get some more people back tonight, and we'll continue to watch the coverage. Listen, close to a 4-hour banger here, about 3:45. We'll come back. We'll hang out. I think this is going to be a good night to hang out. So, yeah, we got to get a break. Everybody needs a break. It's Friday. Maybe we'll go. How about this? We'll just go drive around. We'll do a little driving. Yeah, my eyes need a rest here. I got to get off the computer for a minute. But listen, everybody, thank you so much. We're going to take a little bit of a break. We'll be back in about an hour or two, and then we'll continue. I'm curious. I want to hear Vargas's testimony today. I think that's going to be the most interesting one. Right now, like Tanya was saying, and I was saying, this is a little boring right now, and I'm sure everybody's pulling out. I saw everybody pulling out of the stream, but we'll come back a couple of hours, an hour or two. Look out, 7:30, 8 o'clock, we'll pop back on here, and all the streams should be posted. I'm seeing like East Idaho News is already posting them. But we'll pop out, do a little break, come back, hang out. And I don't know, maybe I'll drop the link for a few people if they want to hang out, come back, hang out on the panel. We'll drop the link. I don't know. I haven't had any guests on in a while, or panelists in a little while. So maybe we'll come back. Well, no, we're definitely going to come back. But thank you. All right, cool. Clary's going to be here. Danielle said, great stream. We need a break. Everybody needs a break. All right, good time to break. We'll be back. I'm sure all the streams will be up here and floating around here pretty soon. We'll find them. I want to hear Vargas's testimony. That's what I'm most interested in right now. Okay, everybody go get something to eat, get some rest, hydrate, whatever you need to do. I'm going to pop out. I got some errands to do real quick. I'm going to post the tile up, maybe back 7:30, 8 o'clock, probably 7:30-ish. We'll pop back on, do a couple hours tonight, hang out, relax, take in all of this Bryan Kohberger news because we've been waiting for this. And I'm going to pop the tile up. Hang on one second before you all jump out. Don't go anywhere yet. Let me do this. I'm going to pop the tile for 7:30. How about we do 7:45? Is that good? 7:45. We'll come back 7:45. And I'm going to do this. I'm going to get the... Hang on. I'm going to get the tile. And I'll drop the link. You can set your reminders. So part 2 tonight, 7:45. That'll give everybody about almost 2-hour break. I'll find all the parts. We'll put it together. That's the tile there. Set your reminders. I hope to see everybody back in about an hour and a half. And we'll do part 2 to the updates today. I think this is a well-deserved break. Okay, everybody be safe. Hang on real quick. We got live coverage from the courtroom, outside the courtroom. Let's pull that up real quick.
T-shirt today that is pro-death penalty in the firing squad bill here in the state of Idaho, and a hashtag on the shirt saying justice for Kaylee. So that's interesting, something that we got on camera as they entered the courtroom earlier today. Inside, we are hearing from defense experts. These are experts the defense hired to help the judge understand what all is involved in the genetic genealogy investigation, how it unfolds, and why, in these experts' estimation, the prosecution should turn over all of those details to the defense so they can be armed with their own experts at the time of a trial and armed for crossing any prosecution experts. So that's the process we are in right now. And what's to come after this part is completed is a motion from the defense to want to put another stay on this proceeding. After a 37-day stay, they want to continue attacking the grand jury indictment against their client here. And then the prosecution has several motions. If indeed this judge wants to grant the genetic genealogy investigation and profiles over to the defense, they're asking the judge to do so under seal. So the hundreds of names that were built inside of a family tree are not publicly released at this point. They also have a motion for a schedule or more of a timeline because this trial is fast approaching in October as of right now, Michael. And of course, we're also waiting. I'm waiting for the arguments over the alibi that the prosecution wants from this defendant as well.
Yeah, lots of big issues today. Chanley Painter, our eyes and ears in the courtroom. Thank you so much for that report. And folks, it is day 6 of testimony in the widower murder retrial. Thomas Randolph is being tried a second time for the 2008.
All right. Good time for a break. I thought that was a great way to end the segment. Part 2 tonight, 7:45 Eastern Standard Time. I hope I see you all there. Be safe. Get some food. Hydrate a little bit, and we'll bang the rest of this out tonight. We'll hang out for a couple hours and chill, and we'll analyze this. All right, I'm gonna hit the outro. Thanks, guys and ladies. See y'all soon.